My lord, may I have your kind leave to mention, my lord, I'm praying for inclusion of an intervening application, lord. Chamber matter, my lord.
A particular application.
Yes, my lord. GA4, my lord. It was before your lordship. My lord, in GA4, on Rashid Ahmed is appearing, and I'm appearing on behalf of him. My lord, there was a direction upon us to file a supplement.
Particular interrogatory application. Particular GA application was being heard out.
GA4, my lord. GA4 was being heard out, my lord. My lord, in this matter, my lord, one Rashid Ahmed, there was a direction upon him to file a supplementary affidavit, my lord. My lord, due to his ill health, my lord, he's an octogenarian person, my lord. Due to his ill health, my lord, he could not come, my lord, to affirm the supplementary affidavit. I'm seeking just 1 week time to come back with the supplementary affidavit, my lord. GA4, sir. Supplementary? No, it has not been filed. Not yet been filed. I'm seeking 1 week's time, my lord, not more than that, my lord.
May I say one? My lord, your lordship's order was on 19 June. Well, I have something to say about the cost title and all these things, my lord. When their order is being recorded.
Was the order passed?
On the 19th? On the 1st July. On the 1st July. On 1st July. During the course of argument, it appears. You got it, my lord. During the course of argument, it appears that one of the documents is not properly annexed in the record. Thus, the intervener in this case, Rashid Ahmed, is granted an opportunity to file a supplementary affidavit on or before 4th July 25, upon service of copy of all the parties. Then, learned counsels appearing in GA4 are requested to come up with written notes of arguments on the other side. Now, naturally, the supplementary affidavit has to be given, and your lordship has also given. A reply may be filed with regard to the supplement.
While you cannot reply.
I cannot. No written notes of arguments.
That be done.
Now, your lordship will kindly come. I am grateful to your lordship that on that day, my lordship had given me an accommodation. This is the order dated 17 July. 17 July. Lordship kindly see this. On the prayer made on behalf of Mr. S. Amjad Ali, appearing for the administrator. I am not administrator. The chairman of the committee, appointed by this court. Well, this has to be corrected, my lord. Well, let this order dated 17 July.
Ali, yeah, the committee.
Yes. Appointed by this court.
Appointed by this court is present. And code of 2000. It's for time. Now. An area. And it is not
Subject to correction, madam. This application is not filed by me, madam. It has been filed by my learned senior friend, madam.
which application you move? What is your application?
GA4, I am one of the intervener, namely Rashid Ahmed, sorry. Rashid Ahmed.
Okay. Appearing for
added party. Most probably added party.
Added party. Submits. Canadian. Not come to court to affirm the supplementary evidence. Once 1 week time is granted, get the supplementary evidence affirmed. Affirmed by 2025. Copy be served One file a reply to the supplementary affidavit also
Yes.
by if any filed by 20th August 2025.
Good.
Let this matter appear on 21/8/2025.
Yes, sir. Now, my lord. Lordship, my lord, in the list, your lordship will kindly see serial number 9. My lord, all these matters are appearing as Sardar Amjad Ali as an applicant. I am not an applicant in all these matters. The applicants are different.
System generated list you see, all these are to be rectified.
But the system has to be rectified. I am not the applicant. These are applications made by some other persons. My lord, may I give a list, my lord, to your lordship's officer so that it can be, the system can be rectified in that as to whose application, yes.
Order dated 1st July 2025, stating the name of Mr. Amjad Ali.
In all the applications.
1st July 2017. Order dated 17th July 2025, stating the name that is Amjad Ali as administrator be rectified and corrected as chairman of the committee.
Yes.
As of Mr. Ali is shown as of the petitioner. Let rectification be made.
Yes.
And the name of the applicant of the respective applications be reflected in the court.
I shall come.
My lord, in this document, the tenure of the administrator has lapsed long time back,
Hear that after.
and I have already filed my affidavit in opposition, your lord.
Hear that.
And my opposition reply has not been filed as on date.
And I will
already
take a
filed-
question, my lord, as to whether they have got anything to say before this show.
Yes,
Whether they have any competence.
yeah, I shall demonstrate the same because I'm up here.
Extended by the court
Lo-
for a particular period till these matters are over. Till these matters are disposed, Mr. Ali may be requested to continue.
As your lordship may direct, that is upon your lordship direction of the honorable court.
Yeah, have
This
you,
matter will appear on 21/8.
Your lordship.
have your lordship's kindly.
21st August.
My reply be given to my officer.
Yes, yes, yes.
No, if he prefers to file, because we have already filed a affidavit in opposition against GA4 and a copy has been served.
Supplementary affidavit is served and thereafter.
No, my lord, I'm to be very precise about the board of Waqf. I have filed my affidavit in opposition to his GA4, to which he has not preferred any reply as on date. So let
But
it
the
be.
appearance of the Board of Work in this matter, I am strongly deposing because there is
It
an
was-
order, the board has nothing to.
The court
of the
had
court.
directed me to file an
It is an
opposition in
order of the
opposition.
Application I am now hearing GA4 probably.
Yes, and in respect to GA4, your lordship, I have filed an affidavit in opposition, compliance to the odd court's direction.
Your opposition.
Your lordship,
Submit
Let the present intervening
Yeah.
applicant complete, thereafter I shall hear you.
lordship.
They are locust and I shall see.
Yes, yes. For the purpose of intervening application, certain papers are still not with us. So I'll beseech your lordship may kindly direct
I am not to supply. The court record is there.
Which application you are opposing?
I'm opposing his very appointment because his appointment is long lost. What is today he is
Now hearing GA4, okay.
lordship.
Any other application you have filed, independent application?
Yes, independent. We have filed for application for addition of parties.
Number to bolo na.
Number for GA 5 to 9, our application.
Okay, okay. This is appearing in the list.
Yes, no. What we want, my lord, that there are certain things which my learned senior friend has relied upon. And our contention is that as of today, he has neither given all these years any accounts, neither given any
Why
invest.
you have filed this GA5?
Yes.
So that is your ground in GA5.
Ground and moreover obtaining a ex parte order without making us even a party. How can I'm a trespasser. I may not be thrown out without the due process of law. That's my only case, my lord.
That is there definitely. Your GA5 will be taken up.
Lordship. J5. Grateful.
Now I am hearing GA4.
J4, my lord.
But
I am a tenant in the property. My application is GA10.
till date, my lord, the position has not been served. Whatever it is, you see, my lord. If
Who is
position
he?
is not served, court will take care of that.
Can I take your lordship's kind leave, my lord? I have got a matter.
Lordship may, if your lordship may kindly direct to find the books of account, because till 1994, the last 1994 till date, no books of account,
That is
no
why-
accounts have been.
You have to pass a direction, I have to hear Mr. Ali, I have to hear you.
Lordship,
I have to
we,
pass a reason order.
he has filed a GA
Well,
in
well,
respect as per the court's direction. We have filed the affidavit of opposition. He had never preferred to file any reply till date. So I may be heard out because I am the board of Waqf.
One at a time, let me take up these applications.
Subject
Okay.
to
And he may be directed to submit the books of account. Your court may kindly do so because
But it is, you see,
my lord, let,
I have to pass a reason order.
my lord, may I submit, my lord?
That I have to hear the parties.
No, no.
lordship, your
My
lordship,
lord, what the Board of Work is saying,
your lordship, if he is an administrator,
my lord, let
He
him
has
take
got a
proper
responsibility.
instruction from the
he has
board.
got a responsibility to file the
Let
books
him
of
take
account.
proper instruction from the
If
board.
I, if,
I
if
shall present all the audited
the court-
statement of account before
don't file it to the board of Waqf, file it before the
all
court.
the audited statement. Till
File it
this year.
before the court.
Okay.
Your lordship may kindly give a direction in this.
I put the court.
Those applications for thereafter.
Lordship, it's a huge estate lying and it has been misappropriated.
One by one, I have to take up these applications. Definitely, I
Sold
should
some
take up
plot.
all the applications.
It's in a very, very sorry state of affair, your lordship, because no accounts, nothing as of date.
He has no instruction at all.
In one line, I cannot.
It is his client who has accepted
Ask a
the
recent order.
audited statement of account.
Anyway, let us consider on the request.
Go and take your instruction from there
Just accepting in the.
He has also occupied.
and make an allegation in writing.
Yes.
We
an
have
allegation
filed
in
an
writing.
opposition in reply. We have filed an opposition to that, to his.
Make an allegation in
We,
writing. I will
we have
reply to
we
that.
have filed a
Yes, I will hold
opposition.
you up.
The next day,
Also
I shall
occupy
get
unauthorized
the
leave.
report and probably.
I've never heard of it.
Lordship, my opposition, your lordship.
73
Lordship,
immediate
আমার
was-
GA8 আছে না?
Huh?
GA8 না আমার?
আমাদের 9 and 11 and 12.
It is your independent
No,
application.
11 and 12.
11 and 12.
What application is yours?
Mine is 4 to 9. 5 to 9, my lord.
11 and 12.
These are the tenants of the premises who
They
are
want
being.
to make a loot of the Waqf property.
But you are not unsafe because nobody can proceed safe and except by due.
Lordship.
My lord, I bow down to your lord. I bow down to
You
your
are
lord.
not.
No, I am not.
Sub condition.
Yes.
Let the board make the submission.
Make
Lordship.
My lord, I will, my lord, your lordship will convene. My lord, upon an order of this court, upon by a division bench, the Board of Waqf in this matter has no locus standi at all.
But if I put a question to myself,
It is a reported judgment.
If his tenure is over, the court can consider.
Lordship, that is
No,
the.
no. Till disposal of this application, he
He remains.
Thereafter, subject to the result.
Certainly.
Certainly.
If the committee's time is over, all right. Let them place it.
What I was humbly requesting, Your Lordship, is the first papers of GA4 application will be provided to us, Your Lordship. GA10 application.
What is your status there?
My Lord, I am a tenant in the property, my Lord.
Very well, just
Let-
I am
let
absolutely
this.
No,
done
first
what is the matter.
ए
If
तुमने
necessary,
अरे
file
बाबा
a
नामटा बोल रहा
If necessary, file
Huh?
a fresh application.
Om Prakash.
Okay.
ওম প্রকাশ ওম প্রকাশ তো একটা হলো তারপর ও সেটাও জানো না
We are great. Lordship.
Yes, state, yes.
সেটাও জানো না
Then will I appear on behalf? Lordship is Lordship.
ঠিক আছে এই ওয়ানটা হলো নাম্বার 1 up to those of the good let this matters appear on 21 and it yes, call item 10.
But item 10, I appear on behalf of the applicant.
Lordship, I am for the decree holder.
Applicant is not a party to the decree. Decree was obtained ex parte. Before I show you two orders, let me, my lord, place the facts because it's very important.
It is imperative from.
Which are complete also.
Yes, may I just say this? Mr. Gupta Milot was leading me in this matter. He's stuck in a 10:30 fixed matter. I am not being a spanner in my Mr. Dev's wheel, Milot, but
It must come ready, not today.
My lord, kindly, my lord, two things is necessary. Why I was playing, my lord, placing this. Kindly comes to page 67 and 68 because without An order be,
Getting protection now.
no, because I want the plain to be produced in court. Kindly see page 67 and 68.
There was a direction.
Yes,
Yes.
because there is a specific allegation and serious allegation of fraud. That's very important because my case is that fraud has been committed.
It is produced.
Plain ta আছে কি?
No problem, sir.
What is the plain?
Plain. আমি তো বেশিক্ষণ বলবো না।
That advocates for the parties are present. The plaintiff is not put up in spite of the direction dated 24th July 2025.
There was an earlier direction also.
Let this plaint be put up
1st July.
on
A week after, because I want to proceed, my lord.
14/8/2025.
Yeah.
Let this matter
Well,
Could it be the Thursday?
Yes.
Could it be the Thursday then, my lord? 14th
My lord,
possible.
I have no difficulty. Only thing what I pray, my lord, kindly fix a time, my lord. I tell your lordship.
Times are usually not fixed.
Very well.
Being witness, arguments.
Very well. I leave it to your lordship. Because it's a serious allegation of fraud.
Matters are usually
কবে
taken
করবে?
up.
বলো তো আমার কোনো অসুবিধা নেই।
I will indicate it is embarrassing. এই 14th 14 তারিখে আসা।
12 তারিখে করো। Because, my lord, this has been pending,
I'm
my
sorry,
lord,
my
for
lord,
last
could it
6
kindly
years.
be the 20th?
Every day you cannot pray for time.
I
Last day you
appreciate
prayed,
it.
I did not.
It was on my account.
একদিন রেডি হয়ে এসো, তুমি আসবে না নয় সিনিয়র আসবে না।
8/2025.
And lordship has directed without
Yes,
any
yes, yes,
fail, but
without
that's very important, my lord.
19.
Lordship has kept it on 19th. Very well, I have no difficulty. But let the plaint come.
Copy of this order is sent to register original site.
No, it was my submission that in any way this is an execution, so my lord's jurisdiction is limited to the decree. That apart, Lord, Mr. Dev is making.
My lord, just 1 minute.
Mr. Dev is making that submission. I don't stand it.
I am not making that submission. Page 68 of my petition says, just 1 minute, why I am making this submission. Probably has not been correctly instructed. There was an order on 25th of September 2023. Why the production of plaint is important. This, the coordinate bench of this court categorically held, may I place it? There is a question of fraud raised in obtaining the decree dated 4th January 1999. That was an ex parte decree obtained. Despite repeated directions, the decree holder has been unable to produce a copy of the plaint filed in this court. They could not. The administrators are represented and submit that the decree pertains to building of Chatterjee International. I am the administrator's third party. I am filing this because execution has been served. Copy. The department is directed to produce a copy of the plaint filed in this court. Leave is granted to the administrators to file a supplementary affidavit to bring on record all necessary facts. I have done, I have filed a supplementary
You
affidavit.
also used our affidavit.
In the certified copy of the plaint.
The supplementary affidavit is to be filed within a period of 3 weeks. I have done, they filed a reply. Now, why is it important that the plaint to be produced? Because there is a question of fraud. Prima facie satisfaction of the court, and
This is a question of fraud that has been raised, not
Anyway,
satisfaction.
let the plaint be produced.
Yes, we
you have
can-
not preferred and I think if the order stands.
It's not a
If there is
finding.
fraud
It's a
or no
submission.
fraud, let the plaint be produced.
Yes, this is submission, Lord. That would have been my submission.
Okay.
My lord, on 19th, my lord, lordship.
Obliged. Dunya the other.
Your Lordship, we are being led by Mr. Dipan Kumar Sarkar. He's appearing virtually.
The degree holder.
Yes.
am appearing for the judgment. My lord, I am appearing for the judgment debtor, my lord, virtually. My lord, I'll just indicate this matter substantially repay. Lord, I am appearing for the judgment debtor, my lord, in this matter. My lord, in this matter, substantial
Yes, what was
Lord, repayment has been made, my lord, which cannot be technologized. We had given our terms of settlement, but the decree holder was supposed to come back with instruction so far as our terms of settlement is concerned, whether it is acceptable to them or not.
Yes, Your Lordship, but the terms of settlement we received on the previous day, we are not acceptable to those. So we would, Your Lordship, I believe Mr. Dipan Kumar Sharkar, I'm led by him, he's not been let in. We have made multiple requests, but he has not been let in. Yeah, his name is
Okay, what is the present position?
My lord, may I indicate one thing, my lord, with your lordship's permission? My lord, in case if our proposal is not acceptable, let them, my lord, give us their my lord, acceptability or any terms which they are acceptable to, so that I can obtain instructions from my clients and come back and give them our terms of settlement which is acceptable to them.
For the decree holder, learned advocate for the judgment dated at present, learned advocate for the decree holder submits the terms of settlement proposed by the judgment dated
Your
not
Lordship,
acceptable to the
Your Lordship, Mr. Sharkar has just been
Mr. Sharkar is there, my lord. Mr. Dipan Sharkar has come logged in, my lord.
mute.
Well, I appear for the decree holder, Lordship. I think my learned colleague has already submitted, Lordship, that the terms of settlement are not acceptable to us. Now, either we proceed with the execution or my learned friend comes back with terms which are more closely related to the terms which are already there and on the basis of which the matter has proceeded so far. Now, Malad, the reason I make this submission and the reason why we don't accept it is because Lordship will have been told that this company was in CIRP, there were difficulties, etc., which is why they were not being able to pay. All those issues have now been resolved. The company has been taken over and by a new entity. So there is absolutely no reason why they can't adhere to the previously agreed schedule and make payment within 2026. If they come up with any terms within which they clear up all our dues by 2026, well, we are agreeable. Otherwise, we'll proceed with the execution. Now, my lord, it's really up to Mr. Ritwan Sharkar to come back with those kind of terms.
Two things, just to in response to my learned senior friend's submission, my lord, so far as the submission that the company has been taken over, it is absolutely incorrect. The company is still undergoing restructuring. We have all possible documents to even file an affidavit and demonstrate before this honorable court. Be that as it may, my lord, since this terms of settlement is not acceptable, all I was humbly praying is that if I can get some indication from their advocate on record as to what is the terms of settlement which will be acceptable to their client, but maybe I will obtain instructions and come back to your lordships.
Learned advocate for the
But the larger intention is to repay because we have paid more than 6 crore rupees, my lord, in this matter.
present. Learned advocate for the decree holder submits that the proposed terms of settlement as submitted by the judgment is not acceptable to his client. Stop. Learned advocate for the decree holder submits that judgment dated be permitted to submit a fresh terms of settlement for consideration of the decree holder. Thus, the parties are granted one more opportunity to sit for discussion with regard to the terms of settlement. Let this matter appear on 26/8/2025 under the same heading.
Deeply obliged.
I'm appearing for the respondent. Lordship, on the earlier occasion, Lordship, I'm for the decree holder. Lordship, receiver has been appointed. Physical possession is the prayer. As per the tabular statement, prayer. Lordship, on the earlier occasion, symbolic possession is there. Stay order is also there. Physical possession with the help of police.
That an appeal is pending.
Lordship, and
Matter appeal last 8 July.
8th July. Lordship, there is a stay order. On the earlier occasions, court was pleased to ask for the stay order, which are unable to provide you on that day. This is stay order. Lordship, there is no appeal. Appeal has been dismissed for default on the fault of the lawyers, and for that client shouldn't serve. Appeal has been dismissed and we are filing a restoration application. There is no stay order, There is a stay order. as the appeal has been dismissed. Appeal is dismissed, but we are filing a restoration application. Today only we are filing. But the appeal has been dismissed. There is no stay order.
When was the appeal dismissed?
17th July, Lordship, on the fall. 17th July. Lordship, we are today only.
Restoration application in the list.
Lordship, we are filing it today only. Lordship, kindly grant us a 2 weeks time. Filed here. Lordship, it's only dismissed on the fault of the Appeal has been on the fault of the advocates only. For that, Lordship, kindly client shouldn't suffer for that. It's dismissed for default only on 17th July.
Stay was passed.
Lordship, we are fulfilling the condition. We are paying 20,000 for the last 1 year, 7 months.
How much you have paid?
20,000 as per the order. Kindly come to Lordship page 3, last portion D. We are paying 20,000 for the last 1 year, 7 months. We are complying with the order. On the month of July also, we had complied the order. The restoration application is not finished. We are filing it. We have the time of 30 days. We are filing it. Symbolic position is there. Lordship, kindly grant us a 2 weeks time. Today only we are filing this restoration application.
Degree holder and learned advocate. Appeal referred against the decree is dismissed for default, for which a restoration application is filed for 2 weeks time. Eight 2025.
Lordship, that copy. Lordship, you can keep it otherwise. Keep it. No.
I appear on behalf of the degree holder. So
for the
after
judgment that
several
Miller.
extensions, they have filed their affidavit of assets.
May I file the affidavit of assets, Miller, as per your lordship's last direction?
Lordship may kindly take up the affidavit of assets for
Yes,
once. हमारे के नीचे judge पे दे दो. Kindly take up the affidavit of assets for once. Lordship, the judgment debtor has not disclosed a single bank account, though at page 2, at 6B, he's saying that he's receiving interest from savings bank for 3,810, and at page 4, if your lordship takes up,
Don't have page 3.
no,
Page 3 there is bank account. Please take my copy.
lordship, the copy served on us does not contain any page.
So, sir. Page 3 there are bank accounts, Miller.
He says he has a due, kindly takes up page 3. He's got shares of 8 crores 72 lakhs. He's got loans made, page 4 kindly takes up. He's given unsecured loans of 20 crores, 50 lakhs, but Your Lordship is not paying my decree.
Lord, the next step, Your Lordship, Lord, will appreciate is the
No.
stage for examination of the
Lordship, I'll
judgment
be-
letter. Let it be examined.
Lordship, there is an ad interim order of injunction passed by Your Lordship restraining them from dissipating with the decreed sum. Your Lordship may kindly call upon my learned friend to at least disclose that that sum is there.
Where is that order? Interim order?
Interim order, Your Lordship will find, initially was passed
22nd August 20.
on 22nd of August 2024.
That order is continuing.
Yes, Your Lordship, it was continuing. It's been extended from time to time. So my decree is just for rupees 38 lakhs,
Not to
91,000. Let him show that that sum has been kept. Your Lordship, 22nd of August.
The judgment.
There was an order restraining them from alienating such sum, the decreed sum. Should let them at least show that that sum has been secured in their bank account. It's not that they do not have the money, but let them show that they've kept such sum. Otherwise, Your Lordship, examination and
much amount lying they have stated.
no, Your Lordship. Your Lordship kindly takes up their affidavit of assets.
Lord, Your Lordship will kindly come to page 3, Lord.
Page 3.
Bank accounts, personal saving accounts, the amount is mentioned. Positive rupees 3,043. Andhra Bank, positive rupees 3,148. HDFC Bank, negative rupees 70 lakh.
79
lakh. ICICI Bank, positive rupees 1,21,423. Kotak Mahindra Bank, positive rupees 14,493. Now, my Lord, B is the description of an order which was passed earlier. C, my Lord, are the shares and stocks. And my Lord, Your Lordship will find at page 4, number 9, that is the unsecured loan. Your Lordship, my Lord, would also appreciate.
So which account?
Yes.
Which bank account you are
Well,
maintaining that balance?
B, we do not have that balance, my Lord, as it appears from this affidavit of asset. And Your Lordship will also appreciate that the affidavit of asset, my Lord, is a particular format, form number 16, my Lord, which we have to follow. So here, through this affidavit, we cannot even write a single letter, which is in addition.
But
Unless Your Lordship, my Lord, grants us such leave. My Lord, the next stage is the examination of the judgment debtor, where my learned friend will be having complete opportunity to ask questions directly to the judgment debtor to wriggle out all answers which he desires.
So that my learned friend
And my Lord, there
can
is
till
no,
then
just a
siphon
moment,
off the
just a
money.
moment. And Your Lordship, my Lord, will then understand whether there is sufficient balance in these accounts or not. We have disclosed.
14 lakh is there.
My Lord,
14,000.
14,000.
We do
They
not have the bank. My Lord, in none of these bank accounts would reflect that there is sufficient balance for the judgment debtor to keep and secure these accounts, these money.
Now, Your Lordship will kindly see the bona fide of the judgment debtor. This order was passed in August 2024. Till then, they have not intimated that they do not have
Learned
the
friend will
balance.
surely call
Thereafter, Your Lordship, when there is a direction for affidavit of assets, they have repeatedly been seeking time, not file the affidavit of assets. Your Lordship has been lenient to grant them peremptory extension twice. Yes, Your Lordship. This is at the date of the filing of the affidavit of assets. And they do not disclose that they do not have the money. They keep on taking time for filing affidavit of assets. When they file the affidavit of assets, they say, please examine my witness, but I do not have the money. I have these shares. Kindly see page 3.
No, I'm not saying we do not
The
have the
shares
money.
they have, they say
have
that
nobody to say
unquoted
this.
shares of rupees 8 crore 72 lakhs, but do not give the demat account number. And then my learned friend says that we have a format which we have to stick to, but that format is only in a format, but you have to give the details. The demat account, he says I have 8 crore 72 lakhs, but what is the demat account number? With which broker have you maintained it, or bank you have maintained with? Nothing. And my learned friend is saying that kindly examine my witness without securing the money. At the end of the day, I have a decree in my favor. He's got 9 crores, around about 9 crores in shares, 20 crores of loan given to a company called Ford Projects, which is again my submission must be an alter ego of my learned friend's client only.
These submissions of the cuff,
But they will not make
there
payment.
is a procedure which we follow in law that is called examination of judgment debtor.
And Lordship, I am enjoying an
Answers come out.
injunction.
If a
That
person is
injunction
not in
passed
a-
by your lordship's court should be enforced. Otherwise, what's the point of giving that injunction? From August 2024, we are in August 2025. My learned friend had kept silent that they do not have the money.
The decree holder will call upon the judgment debtor to produce the bank statements to establish whether there has been siphoning off or not.
Your lordship, in
That
my
is available. That opportunity is available.
No.
It is there.
Whose name?
This is, of course, my lord, in the name of the person who is the deponent, that is the judgment debtor.
But no details given, your lordship. Kindly appreciate. Demat account number, maintained with whom, which bank or broker, nothing.
Sets is filed. That necessary particulars with regard to an affidavit of asset was issued 24th August 2024. That thing. Documentators took time and they have come with certain particulars. Furnishings. View. Are not having sufficient fund to satisfy the degree. Special law. Us.
The judgment debtor, there is only one.
Yes. Us. Special officer. Appointed. Collect. Our client. The statement, bank statement, with regard to the accounts of the judgment debtor of the period 2024 April till 2025. The inquiry we also called that to Andhra Bank. Account number is being 01 5017. Statement from April 2024 till July 2025. Yes. Account number 0691 00005917. The same period. ICICI Bank 10303024 for the same period, and Kotak Mahindra Bank account 98300 particulars of the share stocks held by the judgment debtor from the stock exchange.
Mullah, this is unquoted share.
Yes.
This is unquoted share. This is not quoted share that there is going to be a demat account. Anyways, Mullah, let the special officer inquire into it.
The particulars of the flow. Private limited and Harsh Kathoria will also be collected. Private limited Kolyan Shen security deposit collected at Partition. To the inquiry about notice to the learned advocates. Again, September 29. Copy of the affidavit of assets, as well as the execution application shall be furnished at special office. So, copy will get it.
Grateful, Lordship. Lord is keeping this matter returnable on the 2nd
of September.
Yes.
Lordship kindly extends the interim order till the next
The
date.
interim order granted earlier shall continue for a period of 8 weeks or till further orders.
Grateful, Lordship. Obliged.
May it please, my lord, this is my execution application, my lord.
I am for the judgment.
And I must
in the
indicate, my lord.
lordship's last order.
My lord, I must indicate, my lord.
Yeah.
My lord, I'm not on the GA, my lord. May I only indicate, my lord, an appeal has been preferred, my lord, by the award debtors, my lord. That appeal is pending.
The judgment has been reserved.
CAV, my lord. But I must indicate, my lord, one thing that's very important. I'm for the decree holder, my lord. This
judgment is pending.
Yes.
Judgment is reserved.
Judgment is reserved. It's reserved for judgment. Yes, my lord. But may I only indicate one thing, my lord. The scope of the appeal, my lord, that my learned friend has preferred is only as to, my lord, the computation of a certain sum of mean profit, my lord, the rate at which the mean profit is to be calculated, my lord. Our contention, my lord, it's an execution, my lord. They have already been evicted from the premises. They have left the premises, my lord.
Mean profit.
It's only mean profit, my lord. That has been computed, my lord. Our case was that, my lord, mean profit would be, my lord, rupees 139 per square feet, my lord. Their case was 89 rupees odd. That is the only dispute. That is the only dispute in respect of which, my lord, the appeal was preferred. Nothing more, my lord. They have never denied, my lord, for 1 second that they are liable to pay, my lord. All I am seeking, my lord, at the present juncture, my lord, is an innocuous indulgence. Kindly, my lord, directs them to file affidavit of assets, my lord. That is all, my lord. It's the first step, my lord. Then, my lord, we'll await the appeal court's, my lord, order.
They don't have any hand also. If it been pending appeals, they could have mentioned and get it hard now. But once they don't have any hand.
My lord, I am not standing in the way, my lord. Only directs them to file affidavit of assets, my lord, because in any event, my lord, the execution will follow.
No order.
Not the point.
Lordship,
No, there's no interim order. There's no interim order, my lord.
Lordship may kindly adjourn this matter for 1 week, Lordship.
My lord,
You don't have any hand in that also. You cannot say that the judgment will be delivered within 10 days or 15
my lord, I am not proceeding. Yes, I'm not asking for interim protection, my lord. Kindly directs them to file affidavit of assets, my lord, because that in any event, my lord, will take ordinary course as per, my lord, to proceed with the execution
Lordship, the
application.
judgment has been reserved.
My lord, that
Lordship,
submission
may
will not stand any water, my lord, because their submission was
One-
dispute as to payment of a certain amount. They have never disputed, my lord, their liability to make payment.
Lordship, in
That's
one
not the
more
case.
week, I don't think anything will.
No, my lord, this has been pending for long, my lord. My lord is aware of the law laid down by the Supreme Court in Rowless Shah, my lord. 6 months period, execution application has to be disposed of. I am not, my lord, standing in the way as to the pendency of the appeal. It's not my case, my lord, that I want an interim order. I am only seeking, my lord, let a direction be passed for filing affidavit of assets, my lord. It's in one of India's largest nationalized banks, my lord. A decree, my lord, is staring at them at their face, good, bad, indifferent, my lord.
But Lordship, we preferred an appeal which is reserved.
My lord, an appeal not as to the payment of liability.
Let that be.
Appeal,
Let the judgment be pronounced.
Where's the appeal?
Item 15, I'm appearing for the judgment debtor. I'm being led by Ms. Sanyal, who's appearing. Lordship, let the judgment be passed. Lordship, we have never denied that we will not pay. I'm only saying that let the judgment be passed and we shall.
The judgment, let the
My lord, our claim is tabulated, my lord, in the execution application, my lord. Kindly takes, my lord. para 22 at page 8. That's 4 crores 25 lakhs 86,588. I'm not seeking, my lord, any interim stay. Kindly only directs them to file affidavit of assets, my lord, because
Proceeding with the execution case.
yes,
That amounts to proceeding with the execution.
my lord, only the affidavit of assets, my lord, because
It's also proceeding with the execution case.
Lordship.
very well. I leave it to my lord. My only submission, my lord, is that there's scope of the appeal, my lord. This is my only submission. Rest I leave it to my lord.
One thing.
Yes.
This order go before the appeal court, get some clarity.
No, my lord. That's not what I was intending, my lord. May I only indicate there's scope of the appeal, my lord. We have before the special officer, my lord, that was appointed, my lord, for computing mean profit, my lord. Our claim was, my lord, rupees 139 per square feet should be granted, my lord. Their cases was 89 rupees lesser. It is on that limited scope itself, my lord, that an appeal was preferred, and that is only awaiting adjudication by the appellate court. Nothing else, my lord. They in fact, my lord, they do not have any defense as to their obligation, my lord, to make payment pursuant to the decree.
Lordship, we are not shying away from the payments. Lordship, we are only saying that let the judgment be passed and then we'll.
I'll leave it to my lord.
Learned advocate for the degree holder is present. Learned advocate also present. By that fee which was preferred against the degree of mean profits is honorable appeal for delivery of judgment as the hearing is concluded.
Should carry the appeal papers.
Learned advocate submits that short run may be granted so that if the judgment is delivered in the meantime, necessary steps can be taken up by the judgment dated. And submits not standing in the way of adjourning the matter, but in the meantime, a bit of assets. As the scope of the appeal was only with regard to the quantum of mean profits. So, considering the submissions of both the lawyers, considering the fact that the judgment is already reserved by the Honorable Appeal Court, an opportunity to the judgment dated to take necessary steps on the next date fixed in the evening. This time. Date of this. Second of
I'm deeply
Okay.
obliged. I'm deeply obliged.
Great.
Lordship, I'm for the decree holder. Lordship, praying for a prayer. Lordship, praying for a direction and upon them. Lordship, praying for
One
a
is whose application?
one is what? Our application. For a direction of payment. To praying for a direction for payment.
How much payment you have already received?
84 lakhs 35,000.
Like 30?
Lordship, as per
What payment you have already received?
Lordship.
It will take some time to make further payments. Yes, what you said?
My lord, we have complied with the last order of principal court.
Matter is pending before Justice Bojumdar. This is what order 9/213 application.
Lordship. Lordship, the interim order must be continued. Lordship, as per the last order.
Interim order is continuing. Now, Justice Bojumdar.
Lordship.
And this matter is also due to appear on 26th August.
26th.
Yes. Learned advocates for the parties are present, treated by the learned advocates. The application under Order 930 CPC is due to appear on 26th August 2025 before the bench taking up the said application. Stop. Us. By 2025. The interim order granted earlier till further order.
For the judgment letter.
My lord, I'm appearing for the degree holder. I'm simply seeking for an adjournment, my lord. They had,
The degree holder.
my lord. My
And for
lord.
the judgment letter, madam. Adjourned till 20th.
Let it be adjourned till 20th, my lord. They have
Parties are present.
much obliged.
Grateful, my lord.
My lord, I am appearing for the judgment debtors. I am praying for an adjournment for 7 days, my lord, to take out an
Part
application.
of the degree is complied with.
No, my lord.
This is the separate order matter. That is on 12th. It's a new application below. That the defendant will be directed to file the affidavit of assets. I'm playing on the order in simple order, order in terms of A and B.
So that is order is already there.
No, it is not here. I am seeking the order.
Oh, it is appearing for the first time.
First time, my lord.
Last time I served the copy upon my
Last time it was not served, my lord, directed to serve. They have served. Thereafter, my lord, we are appearing. My lord, today I am seeking an adjournment for 7 days to take out an application for dismissal of this execution case. If my lord kindly sees, I'll point out the defects here and now. My lord, if kindly sees the tabular statement once. Tabular statement. If my lord kindly sees the tabular statement, column 3, my lord will see that the date of the decree has been column 3, my lord. My lord will see that the date of the decree is mentioned as 21st of February 2025. Now, if my lord kindly sees the column 10, prayer A, my lord, an order under Order 21, Rule 41 of the Code of Civil Procedure directing the judgment debtors. So, all of the judgment debtors, my lord, last 3 lines, and they have any property or means to satisfy the decree dated 16-17 September 2025. So, my lord, the date of the decree is not matching with the reliefs that has been mentioned. Now, my lord, if my lord kindly takes the decree once, the drawn up decree once, internal page 2 of the drawn up decree. Yes, my lord. My lord, from the bottom last 5 lines, and upon considering, has my lord found it? And upon considering the oral and documentary evidences adduced on behalf of the parties, it is ordered and decreed that the defendant number 1, Supreme Wood Products Private Limited, hereinafter referred to as the defendant number 1, do within 60 days from the date hereof, that is 21st day of February in the 2025, pay to the plaintiff Siddhant Udyog Private Limited the interest at the rate of 10% per annum on the principal sum of rupees 50 lakh only from the 17th day of February in the year 2016, being the date of institution of the suit till the date of drawing up of the decree, and in default of payment of the interest as aforesaid by the said defendant number 1 within 60 days, such and such will happen. So, my lord, definitely the decree is only against judgment debtor number 1 or the defendant number 1. Now, if my lord kindly sees the cause title, this has been filed against not only the judgment debtor number 1, but against judgment debtor number 2 and 3, against whom no decree has been passed. My lord will kindly see the cause title once. Yes, my lord will see defendant number 1, Supreme Woods Private Limited. Second is Suresh Kumar Beria. Third is Manoj Kumar Beria. And just now I had placed, my lord, the prayers in the column 10 of the tabular statement. My lord, this is against the reliefs have been sought for against all the judgment debtors. But for this purpose, I intend to take out an application. It has already been drawn up. It will be filed in the next 2-3 days. By way of abundant caution, my lord, I am seeking 7 days time to file it.
What do you say?
I'm submitting. Only degree is passed. No doubt is judgment data number 1 is there. But this is defendant number 2 and 3 are the director and the principal officer. So that they are bound to file their representation.
Your tabular statement, what do you say?
I have stated in table statement, we look. That is judgment data.
16, 7.
Third column of the tabular statement.
Third column, 21st February.
21st February 2025.
And
There is degree there.
Is here.
And here it's 16th and 17th of February 2020.
That is typing mistake is there. That is question of the dismissal is there. That is the typing mistake. That can be rectified.
And if they withdraw this application, I
Why?
will not forward this, file my application.
16th February.
That is typing mistake, my lord. That can be rectified by amendment. No problem is there.
Let them take out an amendment application, then I will be filing my dismissal application. Kindly gives us 7
Simple
days. time.
typing the typical error. That is the application able to be dismissed.
Better I give you a liberty to withdraw and file afresh.
No, I am an amendment the table statement, my lord.
Anyway, learned advocates for the parties are present on the prayer of learned advocates. On the prayer of learned advocate for the judgment data, the matter stands adjourned till 12/8/2025.
I'm extremely grateful to my lord.
12 next Tuesday.
12/8 is next Tuesday. I'm grateful to my lord.
I appear for the plaintiff petitioner, my lord, in this matter. I appear for the plaintiff petitioner. Oh, 19. 19 call of it, sir. Oh.
20, yes.
19 fixed at 2 p.m., my lord.
My lord, since we are there, if you lord think, no, we are not. If my lord allows us, we can do it, my lord.
Both of you are ready?
Yes, my lord. This is the matter which Mr. Bagh had argued at length, your lordship remembers.
Yes, let Mr. Tattu submit.
Yes, sir. Grateful, man.
My lord,
You have submitted your written notes also, probably.
Submitted.
It's ready, my lord. We thought we'll submit after conclusion of arguments. Directions were to file.
Yes. Let
Yes.
Mr. Moore does not make any delay. My lord, the present application is an application for judgment upon admission under Order 12.6. According to the plaintiff, my client, the defendant, has admitted in the written statement to the effect that he is a tenant, and because of that admission, according to the interpretation of the plaintiff, that I am also liable to be evicted on the ground of provision contained in the CPC, that is section 2G.
Not CPC, West Bengal Premises.
Sorry, I'm very sorry. Premises Tenancy Act 2G, that 5 years period is over, so therefore in an event I am liable to be evicted. This is the whole crux of the application. My lord, my respectful submission that the plaintiff is trying to proceed on the basis of an alternative case, and rather the contrary to the case made out in the plaintiff. Now, my lord, if your lordship takes the plain once,
It is annexed to the application?
oh, it's a different. I have got another copy. Must be it is annexed. Should be annexed.
That is GA20 probably. Yes, GA20. Let's see the plain.
My lord,
It is not annexed to the
It is not annexed.
my lord, so can you look at it separately? My lord, kindly come to paragraph 7 of the plaint at page 5. Since November 1993, the defendant number 5 has been obstructing the user and enjoyment of the demised premises. Now kindly come to paragraph 15.
the defendant number 5 has trespassed into the open area on the northern side within the boundary of the said premises and has taken illegal possession and control thereof. The defendant number 5 is wrongfully and illegally claiming to be a tenant. Defendant number 5 is wrongfully and illegally claiming to be a tenant of this open area under the landlord plaintiff number 3 and had started depositing rent with the rent controller, etc. 16. The defendant number 5 has no right, title, or interest in the northern side of the area, and blah blah blah. Now, my lord, so therefore, Lordship finds the case of the plaintiff as against me is I am a trespasser. And on the basis of this, and it has been also stated in paragraph 15 that although I am claiming to be a tenant, but it is not, he is not accepting me as a tenant. He is accepting me as a trespasser, and on this ground, now my lord, kindly see the prayer. Prayer D at page 11. Decree for recovery of khas and vacant.
Page 11.
I think it is page 11, my lord.
Yes.
Prayer D. Decree for recovery of khas and vacant position of the pink hatched area as indicated in the plan being annexed B herein on the northern side of the. Now, Lordship has seen the particulars of this property has been described in the body of the plaint itself, and my eviction has been sought for on the ground that I am a trespasser in the premises, wrongfully using and enjoying the premises, and I have not given it up. That is the whole case of the plaintiff. And not only that, my lord, Lordship has seen in paragraph 15 that they have also disputed my legal status as a tenant in the said premises. Now, kindly look at my written statement. Written statement by defendant number 5A to 5C. Now, paragraph 44 of my written statement. I have shown your lordship paragraph 7. Now, how I have dealt with paragraph 11. With regard to paragraph 7 of the plaint, these defendants deny and dispute whether since November 1993 or else there has been any obstruction of the plaintiff to the user and enjoyment of the demised area. The defendants state that the original defendant number 5 now deceased was a lawful tenant under the plaintiff number 3, which they are disputing in respect of the suit premises. During his lifetime, the deceased fifth defendant was an absolute possession and enjoyment of the premises and received usufructs therefrom. After his death, these defendants have been made themselves substituted in place and stead of the said deceased fifth defendant and continued to remain as lawful tenants under the defendant number 3. Now, my lord, kindly paragraph 15 I had shown your lordship. Now, how the paragraph 15 I have dealt it in paragraph 48. Paragraph 48, my lord, I would request your lordship to skip the first 5-6 lines. The sentence starts, my lord, it is specifically denied. Towards the middle, lordship has seen. It is specifically denied that the original deceased fifth defendant has trespassed into the open area on the northern side within the boundary of the
Paragraph 48, page 20.
Paragraph 48, page 20.
Yes.
What's the middle, my lord? The sentence.
Yes, it is specifically
yes,
denied.
it is because they said that I am a trespasser in paragraph 15. It is specifically denied that the original deceased fifth defendant has trespassed into the open area on the northern side within the boundary of the said premises and has taken.
It is not valid. Okay. It is specifically denied that so far as the northern side approach to the demised area.
After that, there are two. It is
okay. It is specifically
yes.
denied that the original deceased.
Absolutely. It is specifically denied that the original deceased fifth defendant has trespassed into the open area on the northern side within the boundary of the said premises and has taken illegal possession and control thereof as alleged. My lord, so therefore, the case of trespassing which has been made out in the plaint, on the basis of which the suit was filed and my eviction was sought for, I have denied that. And not only that, they have also denied that I am not a tenant in the premises. I am a trespasser. So therefore, whole projection of the suit, my lord, is not on the Rent Act. The suit which has been filed, this is not a suit under the Premises Tenancy Act. Because if one person is required to be evicted if he is a tenant, Lordship knows the provision made out in the Act that what procedure to be followed. We are giving a notice under Section 6 and thereafter the other things will come around. So, my lord, on the basis of this fact, the present application has been filed that I have admitted. What I have admitted? That I have admitted that I am a tenant. According to them, it is not. Well, the judgment upon admission means admission of the case of the plaintiff. Admission does not mean contrary to the case of the plaintiff. The case which has been made out in this application, okay, you are not a trespasser, so you are a tenant. If you are a tenant, in any event, you are liable to be evicted under Section 2G of the Act. Can the plaintiff go beyond the scope of the plaint? If the plaintiff could have filed the suit against me that you are a tenant and you are liable to be evicted on the ground of Section 2G and I am giving you notice under Section 6. And if there I could have admitted, yes, I am a tenant, then the decree for eviction could have been passed under Section 12(6) of the Code of Civil Procedure. But this is not the case here. One cannot, my lord, blow hot and cold simultaneously. When he is finding that he is not being able to evict me from the premises on the ground of alleged trespassing, now he is trying to take shelter on the other ground. Which ground is not available under the law in the present suit? Well, this is covered by your own lordship's own judgment. Before I cite that judgment before your lordship, may I be permitted to narrate these things little more? My lord, can you see what is Section 12(6)? देखिए CBC का law. Rule 6. Yes. Now, my lord, kindly 6, judgment on admissions, where admissions of fact judgment on admissions, where admissions of fact, my lord, kindly, I am stretching on this. Admissions of fact have been made either in the pleadings or otherwise. So what fact? The fact made out in the suit, in the plaint. So if
admitting the case of the
plaintiff. If I admit the case of the plaintiff, my lord, whether it is by pleading or otherwise, I am liable to be evicted on the ground of Order 12 Rule 6. If I could admit in my written statement, yes, I am a trespasser, but I have been allowed to stay otherwise, my lord, it would have been an admission. The suit is filed on the ground of not under the as a tenant, but as a trespasser. I am not disputing that I am a trespasser. I am a tenant, and for the purpose of getting the protection under the Tenancy Act, my lord, I am also depositing my rent with the rent controller. And that is what also admitted by them in the plaint. So they were on what provision of law, my lord, they can ask my eviction under the ground of Order 12, Rule 6. No ground is available in the application under Order 12, Rule 6. The plaintiff cannot, my lord, plead a contrary case, my lord, as made out in the plaint. And your lordship's judgment, my lord, is all just on the face of it, my lord. May I show your lordship's judgment? Sorry. Sorry. My lord, sorry. This is the judgment of your lordship in 2023 SCC Online, Calcutta 927. 2023 SCC Online, Calcutta 927. My lord, may I request your lordship kindly take paragraph 7 first. I will take the relevant portion. The learned court below by order dated 18th June 2020. Para 7.
Following decisions are relied.
Yes, yes. No, paragraph 7. Judgment is due. Well, it is the second page of the lordship's judgment.
Yes, paragraph 7.
The learned court below by order dated so was pleased to observe and direct as follows. On perusal of the materials on record, it appears to me that that the plaintiff filed this suit claiming the defendant the statutory trespasser under section 2G of the West Bengal Premises Tenancy Act, and the defendant are claiming them statutory tenant under the plaintiff on the basis of the agreement dated so and so. Defendant already filed the written statement in this case. So the matter in issue is closely related with the main issue, whether the defendant is a tenant under the plaintiff or a trespasser in respect of the suit premises. This issue framed as a preliminary issue and will be considered by taking evidence. The present petition of the plaintiff and the petition under section 712 of the Act will be considered with the above case. My lord, then, my lord, kindly, the discussions, all these things have gone. My lord, kindly come to straightway paragraph 30. However, the provision of section 7 of the West Bengal Premises Tenancy Act provides that the condition laid down in the said section is to be complied with in the event a suit for eviction is instituted by a landlord against a tenant on any of the grounds referred to in section 6. Thus, when a suit is not instituted under section 6 of the West Bengal Premises Tenancy Act, well, let's show the case here. My lord, before I am just, my lord, for 1 minute, before your lordship proceeds further, in the plaintiff, your lordship takes one, kindly, side by side.
This is not a suit under the premises.
Absolutely, and no notice. My lord, the notice which was given by them, that is what I want to show your lordship.
The plaintiff's case is not under the West Bengal premises.
No, West Bengal premises. And that is not all, the notice which was given to us was only on the ground that I am a trespasser. Now, my lord, let me proceed in paragraph 13. Well, against a tenant of any of the grounds referred to section 6. Thus, when a suit is not instituted under section 6 of the West Bengal Premises Tenancy Act by a landlord against a tenant, the compliance of condition under section 7 of the West Bengal Premises Act does not and cannot arise. It will also not be open to the plaintiff to allege that the defendant has not complied with the condition as provided under section 7 of the West Bengal Premises Tenancy Act, where suit is not instituted under section 6 of the West Bengal Premises Tenancy Act 1997. In the instance suit, the plaintiff has alleged that the defendants opposite parties are the trespassers in the suit property. On the other hand, the defendant opposite parties have claimed themselves to be tenant of the suit property. Same in the case here before your lordship. Now, in the event, the defendant can establish themselves as tenants of the suit property, the suit will become non-maintainable. But my case in the written statement, specific case that I am not a trespasser, I am a tenant. And if I could succeed in the suit, my lord, then the suit will go. And will fail as because a tenant under West Bengal Premises Tenancy Act can be evicted only on the grounds as provided under Section 6 of the statute. In such a case, the maintainability of the suit should be decided first in accordance with law. In the event suit becomes non-maintainable, it shall fail. On the other hand, if the suit is maintainable, it has to be proceeded and decided in accordance with law. Then, my lord, kindly come to paragraph 14. My lord, not 14, paragraph 15, it is quoted, my lord, the quoted portion. Admittedly, no notice was issued before the institution of the suit on the ground that the suit was not framed on the basis of cause of action arose following service of notice under Section 6(4) of the West Bengal Premises Tenancy Act. The proposition of law is that notice under Section 6(4) of the Act will be served upon the defendant tenant mandatorily before filing of such suit after expiry of the notice period provided under Section 6(4) of the Act. If the tenant does not vacate the tenanted premises after expiry of the notice period, but here in this case, neither the suit was founded nor framed on the basis of cause of action following service of notice under Section 6(4) of the West Bengal Premises Tenancy Act. The instant suit not being against the tenant within the meaning of the tenant as defined under the West Bengal Premises Tenancy Act, the defendant opposite party is not entitled to get any protection under Section 7(1) and 7(2) of the Act. The present suit essentially being a suit for eviction of a trespasser, which is very much maintainable in the manner in which it was framed on the framed under suit. So, my lord, in that matter, Section 7 and Section 7(1)(2)'s application was under consideration before the court, and the court said since the suit was not under the Tenancy Act, so Section 7 does not lie. So, my lord, under this legal position, my lord, and on the factual matrix, my lord, this application absolutely, my lord, infructuous and baseless.
Distinction is he is a tenant and after a particular period trespasser. But in this case is your client is a rank trespasser.
Rank trespasser.
This is the distinction.
That is the distinction.
Because initially defendant number 5 এর against find করা হয়েছিল, defendant number 5 ABCS.
I think, my lord,
Regarding Justice Sanjeev Banerjee's judgment is very much clear.
absolutely clear.
Your client is not 2G, but your
Because you do not consider me as a tenant. How the 2G will come into operation?
It is your admission or not. Your
admission of what? Admission of the case made out in the plaint. I am admitting my case, which is my case also, which has been denied by them in paragraph 15 of that in their plaint.
If you have concluded, you come with a written note.
I will give a small note, my lord. Yes.
Authorities?
Yes.
Mr. Thakkar has already concluded.
I will have to reply to my learned friend. I have not replied. We are in.
Exchange the written notes.
If he gives me the judgments which he wants to rely on, then I'll have to deal with them, my lord. That is the only thing. Perhaps he has more judgments, I think. If he gives all of them, then we can conclude on the next day, my lord. Otherwise, again, we'll keep.
Exchange your written notes. Let him give a just short reply.
But it would have been better if he could give reply so that I can, my lord.
No, I have no difficulty. I think that is better. Let us conclude our arguments on the next day, my lord, and within 3 days of.
Give a reply on the next day.
Yes, my lord. If my learned friend has concluded today, I can start. I can give my reply. If my learned friend has concluded, I don't know whether he has concluded or not. Let him
the opportunity to submit just written notes and the judgments.
Very well, my lord. So I was only humbly submitting, my lord. if it comes.
Let me do one thing. Let me file my written notes of argument. And they have also relied on one judgment of Justice Bhushan Bhattacharya. I will also make the distinction.
Did you give a compilation?
No. We have not given. We have given any compilation to my lord? No. No.
Give a compilation on the next day.
So, my lord, after that, if my learned wants to give any reply, if I find anything in addition to what they have stated in the plain, I will also give reply to that then and there.
I will only deal with my learned friend's judgments and whatever.
If you reply, you cannot reopen the matter.
No, not
Only
at all.
clarification
Only the
and
point
points
of law. Only the point
points
of
of
law.
little scope. So that is
Only
why
the point of law.
give that compilation, exchange the written notes, let Mr. Dottu submit his written notes.
Absolutely.
And its counsels for the parties are present. Learned counsel for the opposite party defendant has made his submissions on GA 20 of 2024. When shall I keep it?
Any day convenient, my lord. Next 7, 8.
Yeah.
Hong Kong being at a chamber.
Well,
sir.
I have a chamber 8
This is not chamber. This is not.
2025.
Is it possible, my lord, to make it on Thursday instead of Tuesday? Because I may not be.
14/8.
This is not a chamber application.
This is not chamber.
This is not a chamber application. Though it has appeared erroneously under chamber, but not a chamber application.
It ought not to have appeared.
Anyway, the original side rules provide.
14/8/2025.
चलो kindly fix a time.
14 तारीख
देख रहे हैं जज साहब डायरी देख रहे हैं.
So you see 3 days holiday, whether all are you will be busy or not on 14th. That is the
Some program is made by my learned friend.
No. I will be here. মানে
সকালের দিকে হয়ে গেলে better.
বলে দিন আপনি. দেখুন জজ সাহেবের ডায়েরির কি অবস্থা. জজ সাহেবের অনেক মামলা থাকে ফিক্সড.
I am keeping it at 2 p.m. on 14/8. 14/8/2025 at 2 p.m.
Not take much time.
No, and I'm just putting my learn. আমি এই যে মোশনিবি যে জাজমেন্টটা আছে ওটা যে জাজমেন্টস আছে সব রিলাই করছে মানে ওভার করি all the judgment.
Of the notes to us. It would expedite advance copy of the notes.
Have a talk with your learned friend.
Yes, that will.
Definitely supply you.
Okay.
चलिए ना प्रदीप दा दे देंगे आप क्यों टेंशन करते हैं.
Here, one legal application, one is my application challenging the maintainability of the execution petition and the nature of the section 47 on the ground that this is a commercial dispute. And
when was the decree passed?
The decree was passed in an undefined.
If it's already in J1, you are for
the
degree holder.
What I can do is suggest that we had, after the decree was passed, we had filed an application which was in the nature of setting aside of the decree. And before Honorable Justice Krishna Rao, because Justice Rao had passed the decree, that application was
while sitting in commercial jurisdiction.
No. Now, at that point in time, he was taking both the jurisdictions. And no, not now. Now Justice Rao is taking only the commercial jurisdiction. But at that point in time, our application for order 9 Rule 30 was dismissed. But it argues that the decree ought to have been passed, the decree could not have been passed because it is a commercial dispute and will appear from
that argument was considered.
That argument, that observation is there in the decree.
Did you challenge that order 9 Rule 13 in appeals?
No, not in appeal. So order 9 Rule 13
yes,
was dismissed by Justice Rao.
Yes, with the observation
now that summons had been received by us. Now we have filed a review application before Justice Rao on the ground to recall the decree because Justice Rao was trying this particular suit in the ordinary civil jurisdiction where it ought to have been filed commercial dispute.
Now the review application is pending before Justice Rao.
That is exactly what I wanted to.
My lord,
Milord,
review of the earlier decree, not of the order of 913.
No, there is only one decree. So it is a decree which I am, Milord, agreed with. And that is the decree for the matter due to appear.
My lord,
Appearing every
we
Friday
have to exchange the affidavits.
in that matter. But the contention before your lordship, Milord, is same and identical. If your lordship takes up GA1, Milord, right now, I am ready.
Anyway, I am granting you some opportunity. If you are unable to obtain necessary orders, you see, then this execution case has to proceed.
Sir, I am ready with my
My lord,
GA1.
my lord, one thing I may suggest,
I am ready with GA1, Milord. Affidavit is exchanged.
let the decretal amount be deposited before the landed register, as I said. I don't want. Let it be deposited before the register.
Look, there-
If they will
if the
win,
decree is a
they will get back.
taken out an application challenging maintainability, that Milord has to be heard. Sir.
Some interim protection should be granted.
So, Milord,
My lord,
Milord, no kind of protection can be granted, Milord, in view of the judgment. passed by-
Just anyway, it's better you.
Milord, kindly take.
No,
my
it's
affidavit
better if you
reply.
take a review, otherwise on the next day I
Yes,
shall proceed.
But Milord, for your lordship's consideration, kindly come to page 21 of my affidavit in reply. Affidavit in reply?
Your main decree was not appealed against.
No, but review is pending. But review has been filed, Milord, after I have filed GA1. GA1 is first in time. This is the order, Milord, dismissing my order 9 rule 13 by Justice Rao, where Justice Rao observes that this is a commercial suit. Kindly come to page 21. Lordship is at page 20.
yes, that's right.
Milord, kindly comes to paragraph 23. In view of the above, this court finds that the suit filed by the plaintiff is a commercial suit covered under clause 6 of section 21C of the Commercial Codes Act. But this court passed judgment and decree in CS number 220 of 2019 as non-commercial.
My
So
lord,
this observation is there. This is exactly my case.
my lord, thereafter, my lord will.
Yes. Have raised another issue that assuming that this court held that the judgment and decree passed by this court having jurisdiction, this court cannot set aside the said decree in an application under Order 9 Rule 13 of the Code of Civil. And I pause over here only to say that Justice Rao Miller ultimately dismissed my Order 9 Rule 13, saying that under Order 9 Rule 13, you cannot raise a point challenging the decree as a nullity. That is below observed in paragraph 27. And he sees that 27.
Page 36. Well, 26.
That is the last page of the order. The defendants have filed the application under Order 9 to 13 of the court for setting aside of the judgment and decree on the ground of non-issuance of writ of summons. And further, the suit is commercial in nature, but judgment and decree passed in non-commercial suit. As regard issuance of writ of summons, this court has already held that it cannot be said that the notice of the suit was not served upon the defendant. This court already held that the suit filed by the plaintiff is commercial in nature, but neither under Order 9 Rule 13 nor under 151 of the Code of Civil Procedure, this court can recall or review the judgment and decree dated 24th March 2023 passed due to lack of jurisdiction as defendants have alternative remedy under the code. So, Milord, His Lordship Honorable Justice Krishna Rao Milord has made it abundantly clear that it is a commercial dispute. But Order 9 Rule 13 and Section 151 did not empower the Judge Milord to recall the or review the judgment. So we have taken out an application for review. Now, before your Lordship Milord in GA1, it is in the nature of Section 47 on the ground that it is a commercial dispute. The decree could not have been passed by the ordinary original civil jurisdiction, and Milord, the decree should be declared as a nullity.
It was this order passed?
Yes, Milord.
This order was passed on 15th January 2000.
Decree passed?
Decree on 23rd.
March 2023. March 2023. Your Lordship will find that observation at page 26 last time. It is.
When was the suit instituted?
Yes.
In 2019.
2019. But I am not on Patel engineering or pre-institution mediation. I'm simply saying that the court did not have jurisdiction because the court was an ordinary original civil jurisdiction. It was not a commercial. And that, my lord, in paragraph 22 and 27, Justice Rao has made it very clear. Yes, my lord, that is a page.
2019.
Yes.
My lord.
Page 21, your lordship has already seen the observation. This is, my lord, the order which we have annexed in our reply, because this was, my lord, passed after GA1 was filed. Your detailed discussions have been taken
May I submit, my
into
lord?
consideration below. Paragraph 23, your lordship, my lord, has seen at page.
Let us see the date of the decree.
Date of decree, your lordship will get at page 8.
Date
Page
of the
8.
decree, date of the decree, my lord, is in page 20, page 21. My lord.
Well, page of your reply, page 8,
No,
paragraph
shall
5.
we order it? Page 21, my lord.
Running page 20.
No, not the order 9 rule 13, the main decree.
The lordship is only wanting the date. Date, my lord, is written in this order itself.
24th March 23.
Yes. And that is written in paragraph 23 of at page 21, running page 21. Yes, that
When was the depositions taken?
It is on 22.
it was undefended below from our side. So I will
Before
not be in a
Puja
position-
vacation. Probably in
But
the
at
month
page
of
21,
September
the date of
22.
is mentioned. Paragraph 23. 21 at page 21, paragraph 20.
Well, that doubts are taken in
Last line,
in the
of
application under order 9 rule 13. My lord can take that grounds
Here, my lord,
by
Justice
reviewing
Rao
the order, by reviewing the decree earlier.
It's a commercial dispute, Justice Rao.
They didn't prepare any appeal.
It's not an appealable order. It's not an appealable.
Of course. Order passed in or in an application under order 9 rule 13 is an appealable order. It has been dismissed.
I'm not saying, I'm accepting that.
What was the value of the suit?
56 lakhs and all.
The value of the suit, my lord,
56
was well in
lakhs and
excess
all.
of, your lordship, my lord, there is no difference in pecuniary jurisdiction as far as commercial suit or
56 lakhs.
56
My lord.
lakhs. So it's well within the commercial pecuniary limits, my lord, specified value.
My lord will get in my tabular statement, my lord.
My lord, I'm ready to argue, my lord, GA1 if your lordship so desires, my lord, right now here itself.
With regard to GA1.
Yes. Because this is a, my lord, an open and shut case, his observation is already made by Justice Rao. Now, this is my application in the nature of section 47. My challenge, my lord, is to the decree.
Question is,
Yes.
Means this suit ought to have been filed before the
Commercial division.
commercial division.
Yes. Now, my lord, kindly comes to the decree. GA1 at page 40. My lord, our contention is we were not served with the claim, so I have not been able to annex the claim. But let me place your lord before your lordship the decree, because from the decree and observations made there, it is abundantly clear what is the nature of the claim. The plaintiff has filed the instant suit against the defendant praying for a decree for an amount of rupees 53 lakh along with interest at the rate of 18% from July 6th till 5th September 2019 and interest on judgment at the rate of 18% per annum till realization. After filing of the suit, the plaintiff has lodged writ of summons of the instant suit for service upon defendant on 5th January 2022. Plaintiff has obtained certificate from the deputy registrar of this court wherein it was certified that defendants have not entered appearance either in person or through advocate despite of service by way of affixation of summons on the outer wall of the premises of the defendants and in the notice board of this court. As none appeared on behalf of the defendants, this court had fixed the matter in the list of undefended suits.
The plaintiff being the partnership firm carries on business. So this is where the commercial aspect comes in. The plaintiff being the partnership firm carries on business as contractor, engineer and consultant in civil works and other allied activities. The government had allotted a parcel of land being plot number 618 Leather Complex comprising of jail number such and such. The defendant, I am for the defendant with the condition that the defendant would establish a leather industry.
This is an expertise degree.
Yes, so Millard, this is the observation. I can only show your lordship what is there in the degree right now. I can't go behind that. The defendant with the condition that the defendant would establish a leather industry on the said plot and would use the same for, kindly mark this, Millard, use the same for commercial purpose. And if the said plot is used for any other purpose or is let out to third party, prior permission from the government is required. Defendant number 2, who is the managing partner, or defendant number 1 had requested the plaintiff, this is all plaintiff case, had requested the plaintiff for quotation of rates for construction of the building for setting up of leather factory over the land allotted to the defendant. Kindly marks this block. This is the allegation made in the plaint which is set out in the block.
When the matter was taken up, that is when the suit was instituted, a commercial court was established.
Yes, 2019 commercial courts comes into effect from 15th March 2020 by notifications passed by the central government in March 2020.
2020.
Yes,
and this is
And the suit is by 2019.
2019. CS 220 of 2019. So very well, Millard.
The court was established in the year 2020.
Courts have been established in 2000 with effect from 2015. Commercial Courts Act 2015.
Yes, that is there. But
yes.
Regarding the setting up of the pecuniary value, 2018 there was a notification.
2018 there is a notification.
Setting up the
2020 there is a further notification.
Yes.
Now pecuniary value, Millard, with respect to Calcutta High Court, always remains the same. And that pecuniary value is 10 lakh to 1 crore concurrent with the learned civil court. If it is in excess of rupees 1 crore, then it is exclusive jurisdiction of the Calcutta High Court.
In 2018, minimum was 33 lakhs. 2018. 2020, it was made 10 lakhs with regard to commercial.
Yes, Millard. So here, Millard, 53 lakh is the claim.
So 2020, by 2020, the notification, I think the commercial courts in high.
Yes, Millard has correctly identified, but the claim over here is 53. That I have shown your lordship query, Millard, was absolutely correct. Millard, at page 41st paragraph itself, Justice Rao Millard takes this into consideration. First paragraph, page 40. Yes. The plaintiff has filed the instant suit against defendant praying for decree of rupees 53 lakh. This doesn't include interest. This is principal sum. And the purpose why this amount has accrued is given, Millard, page 41, because leather factory was being set up. Last paragraph. Millard, may I kindly place this? Your lordship, yes, paragraph 42, lordship is gone, Millard. Time to time, the plaintiff have raised bill for the work executed by the plaintiffs and defendants have paid payment. The plaintiff has submitted final bill of rupees 53 lakh. So this was their final bill, which included GST for an amount of 8 lakh. On 5th July 2017 to the defendants, and defendants have received the same without any objection. In spite of receipt of final bill, defendants have not paid the balance amount to the plaintiffs, and finding no other alternative, plaintiffs have paid the GST for an amount of rupees 8 lakh. Though the plaintiffs have made several requests to the defendant for payment of balance amount, but defendants have not paid the same to the plaintiff. On 18th August 2018, when the plaintiff number 1 went to the office of the defendants and asked for payment, defendants have abused the plaintiff number 1 in a filthy language and also threatened the plaintiff with dire consequences, against which the plaintiff lodged a police complaint on 20th August 2018. As the defendants failed to pay the amount of the final bill along with GST, plaintiff sent a notice through their advocate on 23rd July 2019, calling upon the defendant for payment of amount along with interest, and the notice was duly served upon the defendants. In spite of receipt of notice, neither the defendants have paid the amount nor have sent any reply to the said notice. Accordingly, the plaintiff has filed the instant suit. So your lordship, I've shown your lordship why the suit was filed. Now, my lord, kindly comes to page 43. My lord, list of exhibits are given, my lord. I'm not troubling your lordship with so much because, my lord, at the execution stage, your lordship, my lord, is not sitting in appeal. So, my lord, kindly comes to page 44, last paragraph. Upon perusal of the pleadings, evidence of the plaintiff, and the documents, it is proved that the defendants have issued work order. Kindly mark. Work order, Miller, that is exactly what is commercial dispute. Work order.
No, there is an observation
Very
of the Justice Rao that it's
Yes.
a commercial dispute.
Therefore, Miller,
Why now the no question of going into that?
I am deeply obliged, Miller. So, Miller, now if I draw your lordship's kind attention, Miller, just for the sake of formality, kindly takes up my affidavit in reply once again, Miller, which I had shown.
Your petition, affidavit in reply.
Yes, Miller, the one which I had shown.
Yes.
Kindly comes to Miller, the order which has, Miller, been annexed over here, the order of Justice Rao, Miller. That with the order, Miller, begins from page 6. And the date of the order, Miller, is 23rd December, 15th of January 2025. Miller, the direct observation your lordship will find at page 21. This was, Miller, as has correctly been identified, Miller. This was my application under Order 9, June 13, where I had also raised the point of maintainability. So, Miller will kindly come to directly paragraph 23. Sorry, Miller, paragraph 21. I'm very sorry. Paragraph 21 at running page 20. 20.
Page 20.
Yes. In the present case, paragraph 21. In the present case, the claim of the plaintiffs is in connection with the work order issued by the defendants to the plaintiff for construction of building for setting up of leather factory. And the plaintiffs have constructed the building for leather factory in terms of work order, but the defendants have not paid the bill amount raised by the plaintiffs. The case of the plaintiffs covered under clause 6 of section 21C of Commercial Courts Act, which reads as follows: construction and infrastructure contracts, including tenders. So, clear observation. The division bench of Andhra Pradesh High Court in Blue Nile Developers versus Moba Chandra Shekhar has extensively dealt with the above clause. The relevant extract is reproduced as below. Hence, from the above, it is clear that the legislature has included various types of commercial transactions to bring under the fold of commercial dispute in case of any dispute arising from any of those transactions. On a careful reading of the above said provision of the Act, it is obvious that the legislature has taken due care while incorporating the above said clauses from 1 to 22 in section 21C of the Act by avoiding repetition of words and sentences without affecting the full-fledged meaning of the same, even on expansion of the said each clause. Therefore, either giving any restrictive meaning or reading of a clause in isolation and expansion of one word only in the said clause would hamper and frustrate the meaningful definition of the said clause on its expansion by abrogating certain category of transactions from the purview of the benefit of the above Act, which is not otherwise the intendment of the legislature in bringing out the said enactment. For the sake of illustrations, if we confine the definition of clause 6 of the above said provisions of the Act to infrastructure contracts only, then it would exclude the category of construction contracts and construction and infrastructure contracts from its purview. Suppose if it read as construction and infrastructure contracts as one word, one sentence, then it would exclude the category of construction contracts and infrastructure contracts separately from its purview. But that is not the intendment of the above said central enactment, as it is clear from the scope and object of the Act. All types of commercial transactions are saved in the section 21C of the Act, subject to condition
that it satisfies the specified value stipulated under the Act for the purpose of assumption of the jurisdiction. But the special court or commercial, by the special court or commercial, except that no category of commercial transaction is excluded from the purview of the above said Act, which is evident from the reading of the above said section and its clauses. In view of the above, this court finds that the suit filed by the plaintiff is a commercial suit covered under clause 6 of section 21C of the Commercial Court Act 2015. But this court passed judgment and decree dated 24th March 2023 in CS number 220 of 2019 as non-commercial suit. Now, my lord, kindly comes to paragraph 27 directly. My learned junior is asking me to show your lordship the act. Your lordship knows this. Kindly comes to paragraph 27 at page 26. The defendants have filed the application under Order 9, Rule 30 of the Code of Civil Procedure 1908 for setting aside the judgment and decree on the ground of non-issuance of writ of summons. And further, the suit is commercial in nature, but judgment and decree passed in non-commercial suit. As regards issuance of writ of summons, this court already held that it cannot be said that the notice of the suit was not served upon the defendants. This court already held that the suit filed by plaintiffs is commercial in nature, but, Manu, this is important, but neither under Order 9, Rule 13, nor under Section 151 of the Code of Civil Procedure 1908, this court cannot recall or review the judgment and decree dated 24th March 2023 passed due to lack of jurisdiction, as the defendants having alternative remedy under the Code of Civil Procedure 1908. In view of the above, GA number 5 of 2024 is thus discussed. Now, may I make one submission? My alternative remedy is twofold. Either I go back to the same judge who has passed the decree to review the judgment and get a suitable order. It would be very easy because that same judge has already made the observation. But in all fairness, I had filed GA1 prior in time. That is the reason why, your Lordship's Court, is also having jurisdiction under Section 47.
Application is pending. Review against the decree.
Against the decree on this same point. But before your Lordship, your Lordship is a court exercising jurisdiction under Section 47, fully capable and empowered to declare a decree as nullity. Observation, is already there by Honorable Justice Rao in this particular order, testing the same question. And I have, tried to satisfy, through the entire decree.
You have stated that you have filed a review application in your application under 47.
Yes, yes. In your
when
application, GA1 was filed, review was not filed. But in my
supplementary affidavit.
Yes, in my reply I have stated.
Okay, reply you have stated.
Yes, I have stated. I was beseeching. It is up to your Lordship, If your Lordship, I would beseech your Lordship will declare the decree as a nullity. Because there is already, a observation passed by Justice Rao.
Let me hear you, learned.
Yes. But I just wanted to formally show your Lordship the prayer I have made in GA1. Kindly takes up the master summons. And this is I am beseeching your Lordship to pass an order be passed declaring the judgment and decree dated March 24, 2023 in CS number 220 of 2019 as nullity, inexecutable, and not binding on the judgment debtors. So this is what I am most humbly beseeching your Lordship in the conspectus that by this time, after Justice Rao has passed the order of 15th January 2025, it has become just a mere formality because that observation is already before your Lordship. I have brought it on record by my affidavit. These are my skills.
What my learned friend submitted, that's all correct. My lord, this application was filed in the year 24. My lord, review application is filed by my learned friend in the year 25. That is on March 25. The grounds taken in the review application are almost same of the grounds taken in Order 9 Rule 13 application. My landed could have filed the review application earlier. He ought not to wait till disposal of Order 9 Rule 13 application. Order 9 Rule 13 application was disposed on 15th January 25. The same grounds of review are taken there. My landed can file the review application earlier. He ought not to wait for the same. He ought not to wait to see that what is the fate of Order 9 Rule 13. My lord, now he is trying to review the expletive decree on the basis of the observation of Honorable Justice Mr. Rao. In his order dated 15th January 25. My lord, there happened 673 days delay, 873 days delay. That application is also pending. Opposition and reply are to be given for the same. And that is due to appear on 28th, I think. Yeah. 28th of this month. That review application, hearing of the review application is fixed. My lord, this is an executing court. Executing court cannot go beyond the decree. My lord, what my landed head is suggesting that to review the decree or to set aside the decree, this executive court has no power and jurisdiction. That I have stated in my affidavit in opposition, my lord. Affidavit in opposition, my lord.
Yes, para 4.
Para 4. 10th June, my lord. If I'm not 10th June. My lord, whatever it may be, that if we have to wait for their review application, my lord, when the application under Order 9 Rule 13 has been dismissed, it is an appealable order. My landed pen didn't prepare any appeal against that order also. Against the expletive decree, my landed pen also didn't prepare any appeal. My lord, it is only to harass and to steal the claim of the plaintiffs. It is the only intention of the defendant's judgment debtor. My lord, so it is my humble submission, my lord, that what I paid, that defendants are to be directed to furnish what assets they have. That order is to be passed, my lord, unless I shall suffer irreparable loss and injury.
Yes.
Even then, my lord, and the last submission, my lord, I don't want the money now. Let the decretal amount of 53 lakhs and odd be deposited before the landed register. Till disposal of the review application, let it be deposited there. If my landed pen succeeds, my landed pen will get returned. If I succeed, I shall get. This is my humble submission.
Just one point of law. Yes. Because my lord, it has been argued that your lordship's court at this moment being executing court does not have the power to set aside or review. I am not asking for setting aside or review. I am asking for declaration that the decree is a nullity. Kindly takes up for formality.
That declaration also cannot be passed.
Section 47 of the Code of Civil Procedure.
Yes.
Questions to be determined by court executing decree. This is middle of the heading. Questions to be determined by court executing decree. All questions arising between the parties to the suit in which the decree was passed or their representatives and relating to the execution, discharge, or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit.
Yeah.
So, my lord, my prayer is kindly declare that the decree is a nullity because the court which has passed the decree was not the court having jurisdiction. This view has been clarified by that court who has passed the decree. So nothing else remains, my lord, for your lordship to basically rule on. Those are my most humble submissions.
My learned friend didn't file section 47 application here.
Application.
No, it is not the 47 application.
Okay. He has taken up the points of law. Learned advocates for the parties are present. Application GA1 of 2024 is taken up for consideration. Our learned advocates. Hearing is concluded. Get this matter. 26/8/2025.
But I don't think so. Written notice is necessary. It's very short constitution. I'm deeply impressed.
36th.
26th.
ওটা তো 28 তারিখে রয়েছে ওটা 28 তারিখে পরে তাহলে করবে
When is the matter due to appear?
That is below the 28th or
30.
22nd.
Anyway,
But
whatever
once
it
in the list, my cause is different and separate before your lordship.
Your remedy is always there.
I'm deeply obliged.
If you fail here, whatever it is, rightly or wrongly, this court will decide.
Yes.
But that is a court with a better jurisdiction, review or appeal.
Honestly, what was troubling me is I had filed GA1 before in time with the same point. That is why I made my submissions in conclusion before your lordship.
Yes, go.
Some personal
Okay, not today.
Personal difficulties out of station. Right. This is that matter where the controversy was on the restoration of the suit, your lordship reverse.
Come with written notes and list of dates. I shall get it.
Yeah, and it's ready, my lord.
Yes.
Yes.
Only written notes and list of dates.
Not today, well.
Well, my application for my lord extension of time, my lord, to file the written statement. It's a very short application. May I, my lord, move it?
Other side.
You were sitting here, my lord.
Can you?
On my other side is here, my lord. May I, my lord, place the application? It's a very small application. Sure.
My lord, I'm sorry to interject. My lord, that previous matter, your lordship made it not today. My learned friend has some difficulty in day after. Kindly make it not this week, my lord. Next week it can be taken.
Not this week.
Not this week, please. I'm so grateful, my lord. Sorry for interjecting.
My lord, it's a very small application. My lord, suit was filed, my lord. Lord, should we kindly take my application? It's my lord GA4. My lord. GA4. Okay, suit, my lord, was filed, my lord, on 2nd of February, my lord, 2010. Old suit, my lord.
When were you served with the summons?
My lord, I was served. Lord, should we kindly take paragraph 3, yes, my lord. I was served with the summons, my lord, on my lord 18th of February, my lord, 2010. But I was supposed to file my lord the written statement on 11th of March, my lord, by 2010. That's my submission. My lord, should we kindly take my lord paragraph 5 onwards? My lord, what happened subsequently, my lord, is which my lord, I have iterated my lord the paragraph, subsequent paragraph at 5, 6, and 7. My lord, the advocate on record, my lord, was entrusted with my lord the matter. My lord, my lord, was diagnosed with my lord a life-threatening disease. Now, my lord, he subsequently expired also in 2012. And there was also a different suit, my lord, which was there. Now, my lord, this suit of my learned friend was subsequently taken up once only before my lord Justice page double.
When did this former advocate die?
He demanded expired in 2012, my lord. But he was suffering from my lord, cancer, my lord. Thereafter, my lord, what happened, my lord, is the suit, my lord, never appeared before my lord any of the suit courts. Lordship will kindly take page 9, which is my lord the first order that was passed after my lord the suit was filed. My lord, I also have a suit, my lord, which is CS 160 filed, my lord, subsequent to my lord this suit. Now, my lord, what happened is, my lord, when this suit appeared, my lord, the submission was made, my lord, on behalf of my lord both the parties hearing that, my lord, both the suit, my lord, should appear and should be, my lord, heard together. My lord, that is, my lord, the order. That is, my lord, there at page 9, my lord. And my lord, this suit was released. But subsequently, my lord, once again, my lord, there was the plaintiff, my lord, did not pursue the suit. Lordship will kindly take the subsequent orders. Non-appeals, and my lordship will remember this is the matter, my lord, which my lord, my learned friend had, my lord, filed a restoration application, my lord, and my lord, it was opposed. And lordship, my lord,
That restoration application was allowed.
yes.
You have a copy of that order?
I'll type annex, my lord, with that page 16, my lord. This suit, my lord, was dismissed in 2023, and my lord subsequently restored, my lord, by my lord's order, which is at page 16. My humble submission, my lord, is that, my lord, the carriage of justice, my lord, the carriage of the suit, my lord, is with the plaintiff, my lord. Once, my lord, the suit was filed.
Your explanation from 2017 onwards.
My lord, 2017 onwards, my lord, the suit, my lord, never appeared before any of the suit court, my lord. And my lord,
see, I think written statement is to be filed in the department.
Written statement, my lord, was to be filed in 2019. It was I ought to have taken out an application, my lord. I do not, my lord, share my responsibility with. I cannot. I ought to have taken out an application then and there. But since, my lord, the suit, my lord, did not appear ever in the, my lord, any of the lists, my lord. My suit was, my lord, going on. My lord, subsequent. There were various orders passed, my lord, in my suit, in the other suit, my lord, which is CS 160. His suit, my lord, got dismissed in 2023. And what I need to explain, my lord, probably is, my lord, 2017 to 2020. That is, my lord, the 2 years, my lord, that I need to explain. 2020 onwards, my lord, because of, my lord, the epidemic that was going on, my lord, the suit, my lord, did not appear ever. Lordship will kindly find the orders, my lord, which I have annexed, my lord. Lordship will kindly see. After, my lord, 2017, Lordship will kindly take page 10. That is, my lord, the first time the suit appeared, my lord, after, my lord, 2017. And this is, my lord, where, my lord, the suit got dismissed because none appeared, my lord, on behalf of, my lord, the plaintiffs. Lordship will kindly take, my lord, their opposition to, my lord, my application. Though, my lord, this application primarily, my lord, is between, my lord, the petitioner and, my lord, the honorable court. Factually, there's nothing much that can be opposed also. But in any event, my lord, I will place their opposition once, my lord. My lord, the standard paragraphs are there, my lord, at my lord, the first page 2, my lord. Then, my lord, the standard, my lord, readings of, my lord, that it's a misconceived application and all. Lordship will kindly take para F, which is at page 3, my lord. That is what, my lord, say. That is their ground. I say the only ground pleaded in the said affidavit in support of Master Servant is laches and negligence on behalf of the previous advocate on record who was therefore heavily about. However, such filed aspersions against this previous advocate has not been supported by any document. It's a 2012, my lord. All this happened. No one is disputing, my lord, that, my lord, the learned advocate is no more with us. And, my lord, that is all, my lord. That is all. Lordship will kindly take para H, which is at page 4. I don't know why, my lord, that has been iterated here. This malware probably is somehow malware. The mistake of copy paste probably. I don't know why they've taken it. These statements as would can you take para each. Besides such blatant statements being made by the defendants in the present affidavit against the previous applicable record, the defense has made an atrocious attempt to take this honorable for granted conduct statements. Present affidavit against a non-existing entity. Well, if they admit that the plaintiff is a non-existent entity, well, that should be remember that is what precisely my argument was when I was opposing the restoration application. That the suit is being pursued on behalf of a non-existent entity. Well, they have admitting here in their own affidavit in opposition that the plaintiff is a non-existing entity. I don't know why they have taken this point here. I believe in prices of copy paste affidavit oppositions nowadays. I do not want to take advantage of this pleading, but whatever it is it is there that it's their admission that it's a non-existent entity. That's all. They have not opposed. They have not justified any. There's no other ground which is
For earlier affidavit in opposition.
yes, yes, which in my while I was opposing the restoration application. That Loshibat had heard extensively at that point of time, and rightly the suit was restored, irrespective of the fact whether it was argued or opposed for 50 minutes.
Anyway, yes, what you
Well, one more there are two judgments which I will want to rely. I'm not placing order 8 rule 1 it's not required. This is one judgment which was also placed by Mr. Mitra in the other matter which was just placed. Well, this is a 2008  11 Supreme Court Wait. Yes. That's 2008 11 Supreme Court 769. Rush will kindly take.
Yes, I shall go through this.
Well, this judgment was also placed by Mr. Mitra in that wherein the Salem Bar Salem Advocate Bar Association
That fine matter.
yes, and people authorized
Any other apart from this?
Apart from this, I would like to keep the Salem Advocate Bar Association, which primarily is the mother judgment with regard to filing of written statements post the 120-day period, saying that the only thing that I want to highlight is that the section says that it's a mandatory provision, shall. The word shall is there. This judgment has explained that the word shall should not be construed as a mandatory, that it has to be filed within the 120 days. It will vary case to case basis, and it's a discretionary power on the based on the honorable court, wherein the honorable courts can allow the filing of the written statement beyond the statutory period of 120 days. This is the other judgment Salem Bar Association. These are my respectful submissions, I know it's a kind of a atrocious application. I do understand after 10 years, but the plaintiff also did not pursue their cause.
See, the application on the proposition that we already one of the speakers. I will myself rely on Salem Bar Association with the Honorable Supreme Court of Salem Bar Association Kailash versus Nam. Category Roshik power to extend the time to state beyond the second cannot be made in a routine. It has to be based on reasons that have to be disclosed by the erring defendant failed to file within the state within the statutory period 120. Roshik kindly notes paragraph 3, there is a clear admission that summons were issued and they were received on 18th February 2010. But in paragraph 4, there is also a clear admission. The written statement, the time to file the written statement expired on or about 11th March 2010. Paragraph 5, Lord should kindly see, these dates are very important. Lord, date Mr. Chakraborty entered his appearance on 20th February 2010. Kindly sees there is also an indication of in paragraph 6 of an application being filed.
and the written statement was extended for 4 weeks. When I don't recollect this order. It's not also been. Page 6, para 6. Para 6. When it was referred to an application, which they had taken out, saying that they have prayed for extension of time to file the written statement by period of 6 weeks. This was also granted, so there was already an extension to file the written statement that was allowed by this. It was not filed. Highly see, unfortunately, there is no quarrel with Mr. Chakraborty being. He had a very untimely death. We all remember him very. Passed away sometime in 20 there. Now, what is crucial over here, as my learned friend has very candidly indicated, they filed another suit against me. Self-same parties, self-same advocate. Subject to correction. I believe Mr. Chakraborty was their advocate in 2010 suit as well. They diligently proceeded with this suit. They were fully aware that this suit was pending. He cannot fasten the liability on me, saying that I did not pursue my suit. As your Lordship has rightly observed, it was incumbent upon him to take steps of filing a written statement, either in the department or if such time had expired, Lordship is aware by filing an application to the extension of time. That has not been done. And I could not understand my failure, but that why he is giving an explanation from 2017. His right stood expired after the order which he says was granted in his favor, extending the time of 6 months. There is no explanation, no cogent explanation, if I may use the. He is given explanation. So, your Lordships are aware even explanations have to be cogent, reasons for delay have to be cogent. So, kindly sees no mention whatsoever. He merely says that I am not taking any steps, but even if I am not taking any steps, that I said in repetition, that does not absolve his obligation to filing the written statement. Suit has not come to the undefended. Not come to the undefended. But he is not, see, the fact remains he did not file his written statement, which he ought to have done. And I think Your Lordship is aware on the original side rules, the timelines are more stringent. Unlike a regular suit. My learned friend relies on Salem Bar Association. I will also rely on Salem Bar Association. My learned friend would probably rely on paragraph 20 or rely on paragraph 21. Yeah, trouble your Lordship. Just 4 or 5 lines. Hand it over to you.
Salembar. Motata.
It's reported in 2005, volume 6, Supreme Court cases, page 344. Lordship would kindly take the trouble to come to page 364. I'm sure my learned friend will rely on paragraph 20. There is no quarrel with the proposition. It was held that because it does not provide any consequence, the word shall under order 8 rule 1 is directed. It kindly comes to paragraph 21. Placetum F. Line starting with there is no restriction. As it thinks. Clearly, therefore, the provision of Order 8 Rule 1 providing for the upper limit of 90 days to file written statement is directed. This is where one has to take the issue. Having said so, we wish to make it clear that the order extending time to file written statement cannot be made in routine. The time can be extended only in exceptionally hard cases. While extending time, it has to be borne in mind that the legislature has fixed the upper time limit of 90 days. The discretion of the court to extend the time shall not be so frequently and routinely exercised so as to nullify the period fixed by Order 8 Rule 1. Well, this is the on same lines, it's paragraph 40 and 43. I will not take that from just get treated as a read.
Same provisions.
Same provision. This is specifically on the issue of my satisfaction is paragraph 43.
Let us formally cite the judgment. That's 2005, volume 4, Supreme Court case, page 480. Paragraph 42 is again says that 42 and 43. May I place it? Paragraph 42. Ordinarily, the time schedule prescribed by Order 8 Rule 1 has to be honored. The defendant should be vigilant. No sooner the writ of summons is served on him, he should take steps for drafting his defense, filing the written statement on the appointed date of hearing, without waiting for the arrival of the date appointed in the summons for his appearance in the court. The extension of time sought for by the defendant from the court, whether within 30 days or 90 days, as the case may be, should not be granted as a matter of routine and merely for asking. More so when the period of 90 days has expired. The extension can only be by way of an exception and for reasons assigned by the defendant and also recorded in writing by the court to his satisfaction. It must be spelled out that the departure from the time schedule prescribed under Order 8 of the court was being allowed to be made because the circumstances were exceptional, occasioned by reasons beyond the control of the defendant, and such extension was required in the interest of justice, and grave injustice would be occasioned if time was not extended. May I just paragraph 43. Prayer seeking time beyond 90 days for filing the written statement ought to be made in writing. In his judicial discretion exercised on well-suited parameters, the court may indeed put the defendant on terms, including imposition of compensatory costs, and may also insist on an affidavit, medical certificate, or other documentary evidence, depending on the facts of the given case, being annexed to the application seeking extension of time, so as to convince the court that the prayer was founded on ground which do it. This is the last paragraph that I think. The extension of time shall be only by way of exception and for reasons to be recorded in writing, however brief they may be by the court. In no case shall the defendant be permitted to seek extension of time when the court is satisfied in the case of laxity or gross negligence on part of the defendant or his counsel. The court may impose costs for dual purposes. One, to deter the defendant from seeking any extension of time just for asking. Two, to compensate the plaintiff for the delay and inconvenience caused to him. So this is, well, I will respectfully submit that for this case, he's only said exceptional hardship. That the delay was filed on laches on part of the advocate, not needed that there were circumstances beyond his control which prevented him from filing written statement. He rather parceling the liability on me. And additionally, he has contested a suit parallelly all these years through, I believe, through the self-same set of advocates, even after demise of Chakraborty. He has not taken any steps in a suit which is adversarial to his interests.
For my satisfaction, my lord, I'll just take 2 minutes. While my lord, my learned friend stopped my lord with my lord this judgment of my lord Kailash versus Nanko. May I read on my lord one more paragraph, my lord, for my satisfaction, my lord. My lord, my learned friend stopped my lord at paragraph 44, but to the that the provisions of my lord Order 8 Rule 1 is my lord discretionary, not mandatory. That's my lord has been settled my lord by my lord various judgments, my lord. My lord, while my learned friend stopped my lord is at paragraph 44. Or may I my lord read for my lord my satisfaction once. My lord, the extension of time shall only be with exception, yes, my lord, and for my lord reasons to be recorded in writing, my lord, I absolutely my lord agree with that, however brief that may be by the court. In no case shall the defendant be permitted to seek extension of time when the court is satisfied it's a case of laxity or gross negligence on the part of the defendant or his counsel. Now, my lord, the court may impose cost for dual purpose. Now, my lord, what my lord this judgment my lord attributes is my lord that my lord it's not mandatory, and my lord at best it can be by way of cost, my lord, where to deter the defendant from seeking an extension of time just for the asking, which I have not, my lord. This was, my lord, an as my lord, my learned friend also agreed, my lord, an untimely death, my lord, of an advocate. And my lord, to compensate the plaintiff for the delay and inconvenience, my lord, may I put this question to myself? My lord, a plaintiff who has filed a suit in 2010 has not even pursued the court, my lord, to have, my lord, the suit listed in the undefended list for, my lord, 15 years. I say, my lord, I am a, my lord, a bad boy. My lord, I have not filed a written statement. My lord, I am taking, my lord, the court for granted. My lord, I have come up with an application, my lord, after 14 years. My lord, if, my lord, what was the, my lord, the plaintiff's, my lord, stance here? For 14 years, 15 years, my lord, they have not taken, my lord, one step, my lord, to have to put the matter to the, my lord, the ex parte board. 2017, in my application, my lord, it was, in my suit, my lord, it was ordered, my lord, that it should be, my lord, tried together. My lord, even then, after 2017, my lord, for 8 years, my lord, the suit, my lord, got dismissed in 2023, my lord, which was restored by your lordship. So, my lord, the delay and, my lord, inconvenience. My lord, may I put, my lord, put it this way, my lord, the suit, because of the delay of, my lord, non-filing of the written statement, my lord, at least, my lord, the plaintiff here and in this suit, my lord, does not stand, my lord, delay or, my lord, any inconvenience, my lord, has been caused to him because of this. They have not pursued their cause under. And, my lord, may I, my lord, read on, my lord, one more paragraph, my lord, paragraph 45. However, my lord, as it reads, states, my lord, no straitjacket formula can be laid down except that observance of time schedule contemplated by Order 8 Rule 1 shall be the rule, and departure therefrom an exception made for the satisfactory reason. We hold that Order 8 Rule 1, though couched in mandatory form, is directory, being a provision in the domain of procedural law. And, my lord, paragraph 46 actually, my lord, is actually this whole judgment of Kailash versus Ramco is basically, my lord, proceeds on, my lord, election petition. So, my lord, that's why, my lord, the judgment of Salim Bar, my lord, is probably, my lord, a more apt judgment, my lord, for, my lord, civil cases, my lord, normal civil suits, my lord. This, my lord, was because of, my lord, trial of an.
The special act empowers the court.
Yes. And that's why I am saying, my lord, Kailash versus Namki is probably not, my lord, the correct judgment for, my lord, suits, my lord, which are to be, my lord, the normal civil suits, my lord, which are, my lord, filed in the original site.
Special act.
Yes, my lord, that absolutely, my lord, my lord, bow down to your lordship. The judgment that more aptly, actually, my lord, applies in this case, my lord, is, my lord, the Salim Bar, which is, my lord, in a civil suit. Kailash versus Namku, probably, my lord, in my humble submission.
This
Kailash versus Namku has been placed by them, my lord, by them, by my lord, the plaintiff.
I want to
শেষ করতে দেখো আর রিপ্লাই দিবি The defendant has placed, I have placed, my lord, two judgments. One, my lord, 2008, my lord, which was also placed by Mr. Miller in the other matter, and I have, my lord, also relied on Salembar, which is, my lord, it was passed, my lord, in a normal civil suit, my lord, not, my lord, under a special act. That's, my lord, my humble submission.
only I want to place.
May I, my lord, file
paragraph 41, your lordship.
Please.
That judgment.
Salim Bar Association.
No, my lordship. That Kailash versus not.
Yes.
Page 4. If you kindly take the paragraph now 41, your lordship.
I'm marking it. Paragraph 41 is already placed.
Already placed.
I'm just marking it.
Yes, your lordship. Constitutes the object and purpose behind enacting Rule 1 of Order Rule 8.
Yes.
My learned friend saying that
if required,
it regards to the election petition only. If that is not the case, your lordship. It is only relied upon the Order 8 Rule 1, your lordship.
If your lordship so pleases, my lord, we may file a, my lord, written notes, my lord.
Learned advocates for the parties are present. Are learned advocates on GA4 of 2025. Hearing is concluded. This matter appeared for order from 21/8.
Will it be lordship's pleasure that we may file my written notes for it?
That's not required.
We'll come back.
Perfect. Why? Okay, leave granted.
Leave to grant.
PM থেকে বসবে
action, my lord.
Yes.
My lord, the defendant, in the family of the defendant, my lord, bereavement occurred, my lord. He is out of station, my lord, due to some reason, my lord. Well, if that
Anyway, let tomorrow mention it at the first sitting.
Your Lordship, I appear on behalf of plaintiff in this matter that's being mentioned.
my lord,
Okay. Tomorrow it
she
will
is for
be.
the defendant, I am for the, she is for the plaintiff.
Tomorrow I shall adjourn the matter. Tomorrow it will be listed. Probably.
Yes, my lord, at 3 p.m.
Anyway, tomorrow I shall.
At 3
Yes. Keep the slip also.
Grateful.
আমরা এর হয়ে appear. Milord, this application, Milord, has come up at our instance. It is for correction. I'm sorry. I'm very sorry. Very sorry.
Anyway.
Or we'll wait for some, whichever you like.
Anyway, 2 p.m. fixed. I am now taking 2 p.m. fixed matter. Both parties are here.
Yes, so it is only for correction. We can wait for one.
Okay. Not today.
Very well, Milord.
Lord, item 24, my lord, is just for withdrawal of suit. Now, all parties are here. Receiver is also here. He wants discharge. I have instruction from the plaintiff to withdraw the suit.
Item 24. Yes, call item 24.
Item 24, over final accounts.
Yes.
From monthly liability, final directly what to do. It's the last page, whether the bank account number is there and the current balance.
This is written instruction, my lord, from the plaintiff.
No. This is collected on account of rent.
From the tenants of the
Up
property.
to, my lord, I had collected till April 2023.
That is the rent and the occupation charges.
Yes, and my order was to collect rent, maintain the property, pay taxes, and if there is any balance, to pay the parties.
Pay the plaintiff.
Pay the parties.
So
Subject to my remuneration.
you have that order with you?
That is not. It's a old order.
No. You see, simpliciter withdrawal of the suit I can grant, but regarding refund of the.
Direct me to refund the amount, whatever is there, equally to the party.
Yes, my lord. According to share, my lord. As the receiver was
Equally to all the parties.
All the parties.
All the parties.
Yes, you are for?
Different number 1.
Is there any agreement with regard to that the amount be?
The parties follow the Islamic law. So there are 2 sisters and 3 brothers. Brothers will get double of what the sisters will get. So brothers used to get the two-thirds of the excess was to be paid to the brothers, divided among them equally. So 2/9 each, and the sisters used to get 1/6 each.
Not some amount can be given to the receiver, my lord, as remuneration. And
When did you last pay the remuneration?
No, receiver
Deducted my remuneration last in April 2023.
April 2020.
After that, my lord, since the suit was not there, I stopped.
Because there was no provision for any monthly remuneration.
There was.
There was.
There was
After
400
2023, you did not get any remuneration.
April, I stopped because the suit was dismissed.
So some one-time remuneration has to be paid.
Yes.
Remuneration is not.
Yes. Learned advocate appearing for the plaintiffs. Learned advocate for the defendant number 1 and Mr. Ganguly, the learned receiver appointed in this matter, are present. Learned advocate produces a written instruction from the plaintiff requesting the learned it is signed by one of the plaintiff.
Yes, my lord. Other plaintiff is dead, my lord.
Oh, by one of the plaintiff, one of the surviving plaintiff to withdraw the instant suit. Stop. Upon hearing the learned advocates and the learned receiver, wherein from the statement of accounts, it appears that rupees 2,99,828.62 is lying on account of rents collected by the learned receiver. Learned advocate submits that the learned receiver be paid his remuneration, and thereafter the parties be permitted to share the residuary amount. Upon considering the submissions of the learned advocate and the written instruction issued by the plaintiff, this court is of the view that this suit should be disposed as infructuous. Thus, this suit number 220 of 2000
withdrawn.
suit should be treated to be disposed as withdrawn. Interim orders, if any, stands vacated. Suit number 220 of 2026 is treated to be is treated to be disposed. Learned receiver disposed as withdrawn করে দিয়েছি।
My lord, dismissed as withdrawn.
আচ্ছা, ওটাকে disposed as withdrawn না দিয়ে dismissed as withdrawn করে দিন। Learned receiver না ওটা dismissed dismissed. Learned how much was the monthly remuneration of the receiver? Yes, 400 GMs per month. Learned receiver is requested to deduct 3000 GMs from the amount which is lying, and upon holding meetings between the parties and their advocates, distribute the balance amount.
In matter thereafter close the account, which was
Thereafter, the learned receiver shall close the account.
which is held opened in
Yes, which is held at the Punjab National Bank High Court branch.
All pending GAs are also disposed of.
Yes, all pending interlocutory applications stands disposed.
Grateful.
Your Lordship, I'm for the petitioner.
ফিক্স ম্যাটারটা তো দেখা হলো।
Yes, GA3.
2 PM
Yes,
টা
25.
মানুষের খুব অসুবিধা হয়। 2 PM লিখছেন কেন তাহলে?
25 Lordship, PLA 324.
So let a date be fixed for hearing this GA3.
No, Lordship.
My lord, item 24, my lord, withdrawal instruction may be kept with the record, my lord. Can you?
ওইটা লিখে দেবেন তো, the instructions, written instructions be kept with the record.
I'm grateful.
Yes, 25. What is to be done in this matter? GA3.
G3 Lordship. On the earlier occasion, your Lordships granted liberty to the petitioner to file the inventory, Lordship, and to provide the report, Lordship. This is a certified copy.
So today is fixed for report of the executor.
Lordship. I filed the inventory, and this is the certified copy of the inventory, Lordship.
Yes, record an order. Learned advocate representing the executor is present. Learned advocate files the inventory in terms of the order dated June 12, 2025. Let the inventory report filed be kept with the record.
The GA may be disposed.
Yes, GA3 of 2025 stands disposed.
But this is that matter where some of the parties to a partition suit have entered into an agreement for settling. Your Lordship remembers Mr. Utpal Bose was addressing your Lordship as the applicant, and then my learned friends on my right have addressed your Lordship as the non-signatory respondents to this memorandum. Now, my lord, I am representing respondent number 1 and respondent number 4.
GA8 din. Where is your opposition?
But we have not filed any opposition.
Yes.
Because, my lord, we are signatories to this document.
Yes.
My lord, kindly, my lord, straight away come to the document in question, which is, my lord, it starts from, my lord, page 76. My lord, the real terms, my lord, start from page 76, my lord. Before that is the cause title. If your Lordship is at 76, kindly, my lord, turn over to, my lord, page, my lord, 10. I'm sorry, page, internal page 10, paragraph 10. This is the real settlement between plaintiffs on one hand and defendant number 1 and 4, whom I am representing.
Yes.
Kindly see paragraph 10.
Yes.
The different numbers 1, 3, 4, and 5, that is my client, some of my clients, shall within the next 6 months from the date of acceptance of the present terms of settlement make payment of their proportionate liabilities dues in respect of premises number 71, 72, 73 Benting Street directly to the statutory authorities, namely Kolkata Municipal Corporation, income tax authorities, and the liabilities towards gratuity payment payable to the staff, and upon clearance of all the dues, the different numbers 1, 3, 4, and 5 will take possession of their respective shares. Now, my lord, this has not been done. Admittedly not done. Now, 11. The plaintiff shall, within the next 6 months from the date of acceptance of the present terms of settlement, kindly mark, make payment of their liabilities of Kolkata Municipal Corporation. The defendants and plaintiff shall not sell their properties up to 6 months. Then, my lord, kindly turns over paragraph 12. The parties agree that the following are the liabilities of each of the parties in respect of AC Estate. Now, my lord, there was a partnership business by the name of AC Estates. All our predecessors or their branches were, my lord, somehow or the other, my lord, representatives in that partnership business. Now, the plaintiff and the defendants have, my lord, charted out what are the liabilities of each defendant and the plaintiffs. Now, my lords, we'll see that gratuity, income tax, and other liabilities are, my lord, tabulated, but no liability of corporation tax is mentioned in paragraph 12. Now, my lord, paragraph 13, all the liabilities in the nature of other liabilities would be borne by the defendant number 1 and 4 only. The defendant numbers 1 and 4 hereby provide an indemnity, thereby indemnifying all other co-sharers to this effect.
All liability in the nature of other liabilities.
All other liabilities, apart from gratuity, income tax, and
yes,
other
gratuity and income tax, that is specified. The other liabilities, that is the column 4.
Yes. Now, my lord, question remains, my lord, and then, my lord, the other terms are there and they have secret. Questions remains. The plaintiff in paragraph 11 has also undertaken to clear off the liabilities of Kolkata Municipal Corporation. Now, if I am not wrong,
no payment receipts of
Their
these-
liabilities.
Yes, no payment receipt has been produced by the plaintiffs with this application or otherwise shown to your lordship that this liability has been meted up. So they themselves also have, my lord, not acted upon these terms. The plaintiffs today ask your lordship, my lord, pass a preliminary decree. I'm sorry, final decree. I'll just read out the prayers, my lord, once. Final decree of partition and, my lord, ad interim orders. So final decree they want to pass in terms of this. But, my lord, this cannot be done because the obligations, my obligations.
Their liabilities means their proportionate liability.
Yes, has to be plaintiff shall within 6 months from the date of acceptance of the present terms of settlement make payment of their liabilities of the Kolkata Municipal Corporation. Has your lordship been shown that this has been done by the plaintiffs? In my very respectful submission, I don't think so. At least till the time I was here in the hearings, but I have not seen. Now, if he has not done so, I have also not done so in paragraph 10. All these are outstanding. So if all these are outstanding, how will your lordship file a final decree? How will your lordship pass a final decree? My lord, the agreement is not that after the court accepts the agreement, then we will make payment. It is not so. Agreement is clear that within 6 months, I will make certain payments. Within 6 months, he will clear off his Kolkata Municipal Corporation dues, and the other parties, other defendants are also there. All those dues of gratuity and, my lord, income tax have to be paid. Corporation tax have to be paid separately. Now, these have not happened. My lord, final decree means final. Thereafter, nothing will remain. No list will be pending before this court after final decree is passed. So all these things have to be done. Where are those, my lord, steps? I am not saying I will not do it. Naturally, I'm a signatory to this agreement. I will have to do my things. But where is their, my lord, bona fide? Where is their action of, my lord, complying? They have also not done so. And, my lord, I heard, my lord, one of the defendants, 678, my lord, the defendants, the counsel appearing for the defendant number 678, my lord, was vociferous in his submissions when he said that even if we are told what are the liabilities, we can pay it off in 2 days. My lord will remember. Now, my lord, I have got, my lord, this is, my lord, dated কত এটা 71 তো 71 তো ওরা তো আছে 71 my lord, since, my lord, the defendants are only in 71 72 and 73 Benting Street, my lord, kindly, my lord, considers at least one of the premises we have where, my lord, the entire dues is Kolkata Municipal Corporation dues is mentioned 2 crore 26. I can, my lord, I've told my client already to bring in respect of 72 and 73.
No, this is 71.
Now 72, 73 also has to be paid up. So, but he says he'll pay it up in 2 days. My lord, let him first, my lord, pay up this 2 crore 26, their share of 2 crore 26 within 2 days.
So the letter is addressed to MN Dastur and Company.
Yes, my lord. This is the rent that has been attached. Because, my lord, these corporation taxes are due. My lord, this is MN Dastur is one of the tenants of AC estate. Now, my lord, since, my lord, none of the parties have been paying the corporation taxes, they have now attached the rent. But, my lord, it is clear, my lord, at least from this document, that 2 crore 26 lakh 68,000 is outstanding on account of 71 Benting Street. Let them come forward. I will give your lordship the 72 and 73 also. My lord, it's a question in today's world, my lord, it's a question of going and getting a LOI issued from, my lord, Kolkata Municipal Corporation. Any, my lord, owner can go and ask for the dues that are outstanding. Let him take it out. It is not that this is within the special knowledge of the different number 1 and 4. Let him go and take it out. I have also asked my client, my lord, my client, one of my clients, different number 1, my lord, it is known to the parties, is very sick. He is not in town. The other defendant is trying his best, my lord. He has given me one. I can give the the rest of the documents also. Fact remains, my lord. So just to sum up, as far as the plaintiffs is concerned, they are asking for final decree being passed in terms of this terms of settlement. I am saying the terms of settlement as per as the terms of settlement also has not been acted upon, neither by him nor by me. These defendants need not act upon it because they are not, my lord, parties. But at least the parties have to act upon it. That has not been done. Second, my lord, the other set of defendants who are non-signatories, how can a, my lord, partial final decree in a partition suit? At least I have not heard of. If it's a final decree, it has to be a final decree in respect of all parties. And, my lord, and the entire list has to be disposed of at one go.
Whatever the defendants who are not parties has stated in the affidavit, that has to be taken into
My
consideration.
lord that's why I'm saying, my lord will take into account if my learned friends are willing, that non-signatory defendants are willing to clear off the municipal dues, which they are to clear off. Well, let them clear it off. Then my lord can pass and can record possibly a further, my lord, direction upon everybody to, my lord, submit to the court's jurisdiction, maybe file an affidavit and record that in terms of this agreement and also otherwise in terms of the original preliminary decree, my lord, everything is disposed of, and then your lordship can pass a final decree. How in this manner, in this piecemeal manner, a final decree can be passed, after which no list will be pending before this honorable court? At least I pose a question to myself, is unknown in law. Parties have to come before your lordship and say, both the signatories and the non-signatories, that look here, the signatories have also complied with these terms of settlement and everything is disposed of, everything is, my lord, sorted, no dues, each and every person is in occupation of their respective portions and all dues are cleared off. And also the non-signatory parties can come and file an affidavit before your lordship and say, yes, we have also cleared our share of the municipal dues in respect of 71, 72, 73. Then your lordship can record. I am not standing in the way of recording the final decree, but, my lord, these, my lord, steps have to be taken before a final decree can be recorded or passed by your lordship. Those are my submissions. I can give your lordship in the form of an affidavit the other two, or, my lord, if your lordship wants, my lord, I can just hand it. I've already handed it over. Your lordship can take note of it.
Give to your learned friend one copy.
I've given to both sets of plaintiffs and defendants. I only have 71 today. I am sure, my lord, within a week or so, I will have 72 and 73. In any event, parties, Mr. Bose's client is not interested in this, but, my lord, the parties on my right who are to pay off the municipal taxes can, my lord, take, my lord, LOIs from the municipality and, my lord, come and let them pay off within 2 days, as they so said.
Is anyone left from the defendant side?
No, my lord, that was.
Well, I shall give a very short reply. My lord will take the Code of Civil Procedure once.
এটা তো নিয়ে গেছে, কোর্টে নিয়ে আসতে।
আচ্ছা ঠিক আছে, আমার বইটা নিন। Kindly see Order 23, Rule 3. Order 23, Rule 3. My lord has found it?
Yes.
Compromise of suit. Where it is proved to the satisfaction of the court that a suit has been adjusted wholly or in part by any lawful agreement or compromise in writing and signed by the parties, or where the defendant satisfied the plaintiff in respect of the whole or any part of the subject matter of the suit, the court shall order such agreement, compromise, or satisfaction to be recorded, and shall pass a decree in accordance therewith, so far as it relates to the parties to the suit, whether or not the subject matter of the agreement, compromise, or satisfaction is the same as the subject matter of the suit.
Parties means all parties.
My lord will let me just formulate my point. So, compromise of a suit is possible. Part compromise of a suit is possible.
Yes.
It must be in writing and signed by the parties, or where the defendant satisfied itself, compromise or satisfaction shall be recorded and shall pass a decree in accordance therewith, in accordance with the part decree. Now today, the plaintiffs, the defendant numbers 1, 3, 4, and 5, have entered into an agreement, recorded in writing, signed by them, and put it up before your lordship so that a part decree can be passed. Why have they done it? Because the terms of settlement which form part of the preliminary decree is very old. Nobody is taking advantage. Nobody is acting in terms of the settlement, and the final decree is not being passed. The advantage which these plaintiffs and the defendants have is that they are concerned only with one property, Engineering Center at 6 Western Street. It is a standalone property. Unlike the other properties, 71, 72, and 73, which have to be shared by and between the other defendants. That is why our task becomes easier when we tell your lordship, this 6 Western Street has been allotted only to us. We are ready and willing to pay all arrear dues in respect of these properties. My learned friend talked about gratuity and other such things which are mentioned in the terms of settlement. They have gratuity and income tax. In page 81, we have shown that so far as the plaintiff's share is concerned, nothing is due and payable towards that. Today, my learned friend,
page 81.
81 of the petition. Now today, it's nil. Others have a due. The plaintiff's is nil. Now today, I have come to a situation when I'm in a position to tell your lordship that this particular property can easily be segregated. Your lordship has seen the tenor of the agreement by the other parties. Nobody says that they are not willing to settle. They are willing to settle if. Now, it is for them to satisfy that if and make an application before your lordship. Today, my learned friend, Mr. Ghosh, hands up a chart which is not part of the pleadings concerning 71. We are not bothered about 71. Today, my lord is not dealing with 71. In my humble and respectful submission, my lord will not look into 71. Today, my lord is concerned with 6 Western Street. Today, as and when my lord sees an application before your lordship by the other defendants concerning the other properties, saying these are the dues, we are ready and willing to pay the dues, my lord will pass a decree in terms of those terms of settlement. But they have not come forward. It is only the plaintiffs, the defendant numbers 1, 3, 4, and 5 who have come forward. And there is another very important aspect also. In the terms of settlement, which is page 80, I read out page 80, clause 10. The defendant numbers 1, 3, 4, and 5 shall within, I'm sorry, page 80, clause 10 and 11.
Yes.
The defendant numbers 1, 3, 4, and 5 shall within the next 6 months from the date of acceptance of the present terms of settlement. So 6 months will start running on and from the date your lordship passes the order. And that is why a self-injunction is being imposed upon them saying that they will not deal with or sell the property. Kindly keep in mind the fact that that self-injunction is not there on the other defendants because they are not part of the terms of settlement. Nobody stopped them from filing a similar terms of settlement saying that we are ready with the money. Their attitude is, we won't pay. We will let the dues mount, but we will not let anybody else pay and take his share of the property. Nobody can say.
Where is your undertaking to share the liability of your dues?
11. The plaintiffs shall, within the next 6 months from the date of acceptance of the present terms of settlement, make payment of their liabilities at the Calcutta Municipal Corporation. The defendants and the plaintiffs shall not sell the properties up to 6 months from the date of acceptance of the present terms of settlement. This is almost like an undertaking.
Question is, you can make the payment of your liability only when you know how much is your liability.
Liabilities. Like they say, anybody can go to the Kolkata Municipal Corporation and find out the liabilities. I know my liabilities. 6 Western Street, we know. We will pay that amount. Once this is accepted by court, within the next
6 Western Street, separate assessment is being made.
Yes.
With regard to that premises.
Like my learned friend showed your lordship a chart regarding 71, though it doesn't concern the present litigation at all. 71, 70, 72, 73, every house, my lord, every building has a separate assessment. If they clear that amount in terms of their proportionate share, They can also become part of another terms of settlement application which they make. But today, just because I am saying the 6 Western Street is a standalone property, I know what the outstanding dues are. Within 6 months, I shall pay all outstanding dues. Nothing remains paid so far as the gratuity and income tax is concerned. Where is the harm of your lordship taking refuge of Order 23, Rule 3 and passing a part decree? As my learned friend says, I have never heard of, I have heard of. It is possible when the agreement is in writing, when the agreement is signed by the parties, and when the agreement concerns a part of the joint family till, which has been exclusively allotted to me. This application I could not have been made if the other defendants, my lord, had a share in 6 Western Street. They don't. This has been exclusively given to me. This terms of settlement would not have been possible if I had a share in 71, 72, and 73 Bentinck Street. That is theirs, and I'm not touching them. Let them enjoy their shares as and when they pay off the dues. They will get exclusive share of the property. But they cannot, my lord, continue to enjoy my share of the property that is allotted to me and use it to their enjoyment and improvement.
So in terms of the preliminary decree declaring your shares, you took the position of that 6 Western.
No.
No, in
not
terms of the
yet.
preliminary decree.
No, it is the estate has it. The AC estate is in charge. All this is tenanted. It's not as if I'm going to walk into an empty building where I will enjoy the fruits of that building. Everything is tenanted. We have a long fight ahead of us. But this is just a small step in the big fight that awaits me to get what is legally given to me and agreed to be given to me under the original terms of settlement, which forms part of the preliminary decree. And I don't say that it is not possible. It is possible.
This is not 6 Western Street came to be the entirety. And there are shares.
Well, I showed your lordship the chart when I was initially making my application as to how page 29, how 6 Western Street came to be. But my lord
Page
will
25.
take 29. And the other shares of the other properties, my lord, have been given to them. But my lord will take it from me, and in fact, nobody will doubt the fact that I have been given 6 Western Street, and they have variegated shares in 71 Bentinck Street,
Yes,
72
6
Bentinck
Western
Street, and 73.
Street.
Yes.
Total area.
To all the breakups are given. My lord, as I said, we have been careful. We have given all particulars. We have given all details. But there is unanimity in the approach. Everybody wants to settle. Now, if you want to settle, why didn't you sign the terms of settlement? Why don't you make the payments which are due and payable in respect of the properties which are allotted to you? You can still do that. But today, coming into my property and saying 71, 72, and 73 ought to be also included is, in my very humble and respectful submission, my lord, not permissible. If they move, they have not made any application. As and when they move the application, I will go and say, yes, please go ahead and do it. They will not move an application. They will not sign the terms of settlement. Yet, my lord, they will stand in the way of a part decree being passed in my favor in accordance with Order 23, Rule 3. Well, those are my respectful submissions. If my lord wants a small note,
yes,
I can give a note.
Bring a written notes of arguments. I'm giving you a few days' time.
My lord, by next Monday.
Monday, my lord, I'll also bring, my lord, since Order 23, Rule 3 has been cited by my lord.
You give it in your written notes.
Yes, I will just include some judgments, my lord, which says, my lord, clearly all party, yes, part decree is possible, certainly. But then all parties to the suit have to agree to it. Part decree cannot be part defendants and part plaintiffs.
Their affidavit shows that they are agreeable. The modus operandi, they do not agree.
Yes, record an order.
Everybody is agreeable.
Yes, yes. Learned advocates for the parties are present. Hearing is concluded. Learned advocates are granted liberty to file written notes of arguments on 11/8/2025. I'm keeping it as to be mentioned on 11/8/2025. Let this matter appear on 11/8/2025 as to be mentioned.
I'm very grateful to my lord for the patient hearing.
Item number 27.
Yes, take back your book.
I appear for the defendant. My lord, in item 27, I am appearing for the respondent number, defendant number 4A and 4B, my lord.
Yes, item
27, my lord. In last week, my lord, I have received the affidavit in opposition in connection with the GA18 of 2023. My lord, kindly grant me liberty to file one reply, my lord, to that effect.
No, GA18 is the plaintiff's application.
No, my lord, it is the application filed by us.
My lord,
Defendant number
may I
4A and
assist your
4B.
lordship? My lord, it is an old partition suit. In this partition suit, as per terms of settlement amongst the family members, the preliminary decree has been passed long back in the year 19.
My lord, opposition.
GA18 is for?
GA18 is
Well, may I, lordship? The preliminary decree has been passed. The erstwhile partition commission filed his report in the year 1977, long pending partition suit. What has happened, lordship, during the pendency of the partition suit on the basis of preliminary decree, the parties have already acted upon. My lord, they have filed now, the defendant number 4A and 4B filed one application for appointment of fresh survey first commissioner.
You have filed your opposition to that. Why have you not
Yes,
filed?
yes, we have filed, lordship.
Actually,
at that point of time,
you see, when he has filed an application, let me either allow or dismiss it.
Yes, my lord.
So,
Now,
what
what I am on, lordship,
if his application is frivolous, I'll dismiss it. So
My
let
lord,
him file the reply.
being
I'm for the plaintiff.
Yes.
Now, there are several applications pending before law. My lord, all the applications are redundant and infractual.
Very well, let me hear them.
My lord,
If it is redundant, I'll dismiss it.
Now, by down your lordship discussion, my lord. My lord, what happened? That 1 month, 1 week ago, my lord, I have supplied the copy of my application. They don't seek for any application. I will reply to that thing.
1 week ago, you have served them.
Yes.
My lord,
Before, my lord.
there was no direction.
My lord, this application, this suit was of 1960, my lord. Preliminary decree has filed in 1963, my lord. Preliminary decree filed on the terms of settlement. Their predecessors, my lord, they have given the terms of settlement, they have given the consent, my lord. Now, what happened? My predecessor also gave the consent. Thereafter, appointment of the partition commissioner was appointed in terms of settlement as well as the preliminary decree. Now, what happened? He has filed the report in 1977. After thorough investigation, scrutiny, everything, no one make any objection to it. Now, defendant number 4 and 4B comes with various applications. My lord, all are redundant.
This 221 is for?
My lord?
J21.
Yes.
21 is for what?
For my lord, for
21 is
transposition.
only for the appointment of a special commissioner.
My lord, GA21 is for transposition.
23
21, 23 is for transposition. My lord, why it is
They want to transpose themselves as
yes,
the
my lord,
plaintiff.
as because the
I'm
my lord,
here.
as because the my lord,
Yeah.
plaintiff was not appearing for last 2 years.
Because of some problem.
My lord,
But I am here, so those applications are
my lord,
redundant.
as because the
Are
plaintiffs
the
were
affidavits
not appearing
complete?
for last
Are the affidavits complete? in this
affidavits
GA?
were complete exchange between the party, all other respective parties.
No.
But
GA
as
21,
because
23. Are the affidavits complete?
my lord, no.
They
Only
yes,
plaintiff used affidavit in opposition against
GA 21, 23 and 24, you have not filed affidavit. Yes.
my lord,
They got an order.
My lord,
Advocates for the parties are present.
my lord,
GA,
before
yes.
passing order, kindly, lordship. In GA18,
Yes.
affidavits have been completed, but
Reply is not yet filed.
Plaintiff has
well,
filed
affidavit reply has been given by us, lordship. Kindly appreciate, lordship.
GA18 is whose application?
my application.
Application filed by the defendant 4A and 4B.
Then how can
For
you give the reply? You have given the opposition.
No,
Yes.
they have
No,
filed the
my lord.
opposition.
Yes.
They have given the reply to their opposition. But I am with your
Now,
lordship, my lord, I filed the opposition.
Plaintiff came later.
Plaintiff
Very
came
well.
later after 2
Yeah.
years.
Yes, not for any.
So to your opposition, let him
Yes,
file
my
the
lord.
reply.
Grateful, man.
Learned advocate for the
And
applicant
also one more
GA18 of 2023 intends to use an affidavit and reply intends to use the affidavit in reply to the
affidavit in opposition submitted by the plaintiff. Such prayer is allowed. The affidavit in reply may be filed
Very short date, my lord.
on or before 14th.
My lord, kindly 11th, my lord, let the matter hard out on 12th.
Fixed on 18th.
My lord, I'm
Okay, on or before, just a minute. My lord. On or before 12th, let this matter appear on 14th.
My
lord.
Yes, please
My
don't
lord,
pray for any
my lord,
adjournment
my
on the next
lord,
day.
My lord,
one more thing, lord.
my lord,
kindly-
my lord, they will come.
My lord,
Let-
kindly appreciate
No
lord.
further adjournment will be granted.
My lord, 63, my lord, 63 preliminary degree passed on various, my lord, all the attempts.
Now only final degree is required to be passed.
My lord, may I submit lordship? This GA 18, it was filed by the defendant number 4A and 4B for appointment of new survey post commissioner. Accordingly, new survey post commissioner along with other commissioners were also appointed.
You have taken this in your
Yes,
opposition?
my lord, kindly, we have taken this point, lordship, and we visited the spot. We have filed our report, lordship. So, according to
let us
my
do one thing.
submission, it application has
Let
become
all these
infructuous.
applications be heard out
It's
on
become
that day.
infructuous.
That day, my lord, that application GA number 18.
Wait.
No, it is their own application. They prayed for appointment of the new survey post commissioner.
14 তারিখে 3টের সময় দেখুন তো কোনো ম্যাটার আছে কিনা।
Well, kindly appreciate one thing. In their
It's better argue on the next day and complete the matter.
no, I'm only assisting lordship for bringing the correct fact.
3টের সময় নেই। আচ্ছা এটা 14 তারিখে 2 PM করে দিন।
2 PM.
2 PM. Grateful, man.
My lord, if the hard out, my lord, that GA number 21, everything will be solved.
Yes, let
Other application is
let
not
all
required to be
applications be
heard.
heard out.
My lord.
Other application need not to be hard out.
All other applications have become infructuous.
Yes, 18 will be heard out all analogously.
And one more thing, my lord, pursuant to your lordship's direction, 16 June 2025, my lord, your lordship directed to share the 300 GM, my lord, to the joint.
My lord, we
commissioners.
were appointed the special officers.
My lord was
We
directed
visited, we
my lord-
got only
my lord,
initial
yes, your lordship,
information.
Paragraph 6, my lord.
Yes,
The
so there was a
commissioners-
direction to share the
commissioners
remuneration.
without prejudice to their rights at this stage shall receive 300 GMs each to be shared by the parties. My lord, my clients 4A and 4B come up with the check, my lord. Should I hand over, my lord?
Yes, why are you
Fine.
delaying it? Yes, hand over the check.
My lord, on 14th, my lord, at 2 PM.
Yes.
Item number 28.
Waiting for the plaintiff, I am led by Shonatan Ghosh raising virtual mode.
That matter where my lord they asked for a preliminary decree on the basis of the report and compilation lordship
My lord-
directed to file. We filed the compilation.
Yes, let it be heard out.
Yeah,
Taken up.
exception application has also been filed, my lord. Needs to be heard.
Darcy, I appear virtually.
Yes. This is the compilation and written notes.
Yes, written notes I have already filed dispute now relating to 2 floors, ground and first.
This covers both the suits.
Only one suit, partition suit, preliminary decree passed, commissioner of partition appointed.
Yes.
He filed a report. We took an exception. Then finally it came up for hearing before Honorable Justice Arindam Mukherjee.
No, CS 212. We are appearing for
Defendant.
Yes. So this is the compilation submitted by you.
Compilation submitted by me on the last day. Lordship directed both of us to file. We filed it on the last day. Today my
Yes.
learned friend
This is the
filing.
compilation.
Yes.
And your written notes is submitted earlier.
Yes, I have filed my written notes on earlier occasion.
Yes.
Important thing, my lord, before my learned friend addresses, it would be, I think, beneficial to the court if lordship sees, my lord, the page 25. The order of Justice Mukherjee passed on 17 December 2019. Then lordship would find what would be the real dispute now and why the report filed earlier needs to be considered. 17 December 2019. Kindly consider this report once.
Yes, page 25.
Page
Running page.
Running page 25. No, sorry, but page 15, I think. I'm sorry. Annexure C. The order dated 17 December 2019 of their application.
59.
Kindly seize this order, then will let my learned friend addresses the court, then I would give my reply.
Yes.
Yes.
Yes, Lordship, this is my application for passing a decree. And that decree report was submitted by the Partition Commissioner in compliance with order of Justice Arindam Mukherjee. And Justice Arindam Mukherjee on 17th December 2019 passed the first degree in respect of the dwelling house of this property, joint property. Prior to this, that report is submitted on 7th April 2017. And for both of the properties, one at the Lenin Sharoni, 124B Lenin Sharoni, and another is the dwelling house. And in both of the properties, the defendant has taken exceptions in GA number 1933. And mainly that exception concerns with the dwelling house of the third floor, which has been disposed of in respect of the third floor, and the exception failed in the third floor. What has happened? The 60% was insisted upon to be given to the defendant by the plaintiff, and in the open court, before the Lordship Justice Mukherjee, they agreed that we'll provide 60%, plaintiff agreed we'll provide 60%, and defendant accepted that he will also release 10% more in favor of the plaintiff from any of the floors. And that floor was in the ground floor, particularly the first floor and second floor was occupied by the tenant, and that 10% was possible to be allotted by the Partition Commissioner from the ground floor. And that was the direction of the Honorable Justice Mukherjee. And in respect of the other floors, the defendant has admitted in the GA petition that I have no objection in the respect of the first floor and second floor, because all are in same area. I have no objection in giving the 10% excess from any of the floors if the plaintiff agrees to release 10% more in the third floor. That has occurred. Now the report has been submitted on that basis. Delivery has been given by the Partition Commissioner, and that is final. There is no scope to open up. But in respect of the first floor, second floor, and the third floor, the report is that first floor to be given to the plaintiff, second floor to be given to the defendant, and the 10% extra. That means 10% extra which has been given in the third floor to the defendant excess. That should be the issue. Justice Arindam Mukherjee's direction was that that should be given from the possession of the defendant. But the report says that 10% of the excess area to be adjusted by them mutually. But that mutual adjustment has not been successful, and therefore presently the admitted position is that first floor is admitted, second floor is admitted, 50% is admitted in the ground floor, and that 50% ground floor has been given in the southern side. And then southern side, what has happened? The plaintiff insisted on the first degree that he will take the southern side in the south. Instead, he will be given any side or any floor to the 10% excess to the plaintiff. And that has happened. And during that time, when the surveyor was appointed, meeting was held by the Partition Commission, they accepted it, and they did not put any objection in the GA number 133 in respect of the southern side. It is in the page 23, clause paragraph 37 written. And now, Lordship, it is a very clear case that the decree should be passed on the basis of the admission. Decree should be passed in the basis of the 10%. If your Lordship decide that 10% will be given to the southern floor, then that should be decided by, until it is decided by respectful submission before your Lordship, that As per admission, first floor, second floor pass another degree, and 50% another degree, and 10% and another property in 124B Lenin Survey will be passed in the third degree. Kindly allow the petition of mine, which has been filed in the month of July 2004, and hold the matter should be as an integral part my application, that objection of the affidavit in objection and affidavit in reply and lordship order is the compilation will be the evidence of all the records, and that is sufficient for passing the degree. My respectful submission, kindly pass the second degree in respect of the first floor and second floor, and the 50% in the ground floor, in the third and fourth. If it is not possible, then kindly pass the first floor, second degree on the basis of admission, and give the matter on hearing for the 10% excess and the southern side. That I will submit later on. But Lordship, kindly, this is the position. My client is suffering from cancer. He stays in Delhi sufficiently. He will not be seeing the result of the fate of this partition suit. It has been filed in the year 2010, and repeatedly the defendant, though all are clear, repeatedly filing the exception petition application and everything. In this way, they are trying to delay the matter. And when your lordship will pass the decree, my client will not exist in the world. This is my respectful submission, lordship.
Yes, let Mr. Dev submit on the next day. I'm keeping it tomorrow. কালকে দেখুন তো 3টের সময় আছে কিছু।
Lordship, I want to submit one thing. As per original side rules, order chapter 16, rule 6, that every degree before passing the degree by the original side, that should be given in the peremptory list. Peremptory list, that should be given. That is the rule of the original side. Order chapter 16, order 6. Shall I quote it, sir? Sir? I'm just reading this provision, Lordship. That provision are with me. I'm just reading that original side rules.
Tomorrow, can it be fixed on next Monday instead of tomorrow?
Therefore, day after tomorrow, I'm keeping it.
Lordship, no degree unless suit appears in the peremptory list, subject to provision of the chapter 18A. No degree in a suit shall be placed unless the suit appears in the peremptory list of the suits or the day. So kindly put it in the peremptory list.
When can you give your written notes of arguments? Have you filed?
Yes, sir. Lordship.
Can you come with your written notes of arguments?
Have I filed the written notes of argument previously? And thereby I have specifically mentioned that this matter of passing the previous degree has become res judicata, final, and he has not appealed, and it has been doctrine of estoppel, so he could not take any objection in respect of this. So it is and judgment has been passed.
Advocate for the plaintiff has concluded his submissions. Fix. Yes, I'm keeping it on Thursday.
Thursday.
Yes.
My lord.
Thursday?
Thursday, 7th. Fix 7th.
7th, it's not a problem, Lordship. I am in Delhi, so I will be on virtual.
For final submission of learned advocate for the defendant. আচ্ছা বৃহস্পতিবারে দুটোর সময় আছে ম্যাটার দুটো আর তারপর
kindly giving the peremptory list.
আচ্ছা 2 p.m.
At 2 p.m.
Thursday 2 p.m.
Lordship. Great.
Item number 29.
Yes, 28, 29. না না, learned advocate for ওখানে তাহলে এটা করে দিন, learned advocate for the defendant in yes. Okay, suit is only one suit, 212.
Yes, ma'am. Two GS are there. One.
Yes. Okay. Learned advocate for the defendant. ঠিক আছে, একই অর্ডার, দুটোতে একই অর্ডারই হবে।
28 matter J number 7 2028 and 29 J number 9 2024.
Anyway, I am recording that the learned advocate for the defendant to make the submission on 7. ঠিক আছে, যা আছে না দুটোতেই একই অর্ডারই হবে, একসাথে করে দেবেন। ঠিক আছে, হ্যাঁ একসাথেই করে দেবেন আর কি। যদি ম্যাটারটা দেখে দিন।
Item number 36, 3 p.m. fixed matter.
Your Lordship, in respect of item number 30, I'm just humbly praying your Lordship that it's a old suit. Your Lordship was pleased to direct the Administrator General to give to the plaintiff. They are not appearing for so many days, your Lordship. Kindly pass necessary order, your Lordship.
Is 30.
In respect of 30.
Okay, let me take up the fixed matter. Thereafter, I shall see. If not possible, tomorrow I shall take it up.
Oh, yes.
Yes, 36. Yes, you are for the defendant.
Yes,
Who is appearing for the
my
petitioner?
witness. Chief. Shown. স্পেলিংটা দেখে নিও, হ্যাঁ, JI হেঁটে দেবে। There are certain corrections in the deposition on the last occasion, my lord. I'll point that out at the end today.
Some corrections to be made regarding serial number.
No, there are typographical mistakes, serial number, a lot of things. I will point that out. Shown your answer to question 41. Full stop. In answer to the said question, you have said that the testator and his wife, open inverted comma, testator থেকে open inverted comma, testator and his wife were there till about September 2008 until their daughters came and removed them from the Roland, ROWLAND, road residence, close inverted comma, full stop. Can you please elaborate what you meant by the word removed?
There were primarily two incidents that took place which led to the removal of the testator and his wife from our Roland Road residence to their Roopchand Mukherjee Lane flat by their daughters. In June 2008, the testator sold his Sheikhpura land with the sole intention of distributing the proceeds amongst his children. The first dispute arose in August 2008 when Mrs. Preeta Banerjee, being defendant number 1B, found out that the entire proceeds from this land sale was being distributed only amongst his daughters, and none was left for her father, Dr. Praveer Kumar Banerjee. She thereafter called the testator to find out regarding her father's share. When the call came, apart from me and my husband, the testator and his wife, Mrs. Archana Mukherjee, and her husband, Mr. Bijon Mukherjee, and Mrs. Chandana Chatterjee were all present there. Upon being asked as to her father's share, the testator said, yes, a share will be left for his son. However, before he could proceed, Mrs. Chandana Chatterjee, who was standing close by, grabbed the phone, turned off the speaker, and thereafter, a huge altercation broke out between Mrs. Preeta Banerjee and Mrs. Chandana Chatterjee. Thereafter, using this as an excuse, the daughters said that they would want their parents to be removed from the Roland Road residence. After this, my husband, who was present there, Dr. Praveer Kumar Banerjee, explained to the testator that as a granddaughter, Ms. Preeta Banerjee was only concerned about her father's financial well-being. Thereafter, the testator and his wife stayed back at our Roland Road residence. The second incident took place sometime in September 2008, when the testator, being 89 years of age and a chronic cardiac patient, had a sudden recurrence of arrhythmia and started feeling very unwell. Seeing his condition, my husband, who was the primary caregiver, suggested that his father be hospitalized without any delay. However, paying no heed to this, Mr. Ranjan Chakraborty, being one of the sons-in-law of the testator, expressed his urgent desire to convene a meeting with the testator and his wife and the daughters and Mr. Bijon Mukherjee to sort out the testator's financial matters. At this juncture, my husband intervened, Dr. Probir Kumar Banerjee, tried explaining to his mother that priority be given to his father's health over the financial matters. Unfortunately, he did not succeed. And thereafter, Mr. Ranjan Chakraborty proceeded, along with the rest, to have a closed-door discussion, leaving my husband and me aside. After a while, when they came out of their closed-door conversation, we saw them that they were ready with packed suitcases containing the testator and his wife's belongings. The testator's wife then said to us that they had decided to go along with their daughter's wishes, and they were leaving the Roland Road residence for their Roopchand Mukherjee Lane flat. Hence, I said that they were removed from our residence.
In your answer to the previous question, who do you refer to by the word daughters?
What I meant was Mrs. Archana Mukherjee and Mrs. Chandana Chatterjee.
Which daughter of the testator was Ranjan Chakraborty married to?
Mr. Ranjan Chakraborty was married to Mrs. Ranjana Chakraborty.
Was it usual for the testator's daughters to visit him at the Roland Road residence?
All the daughters, excepting Mrs. Archana Mukherjee, resided outside Kolkata. They would often drop in to visit their parents as per their convenience. It was customary during these visits for the daughters and their families to have closed-door discussions so that my husband and myself were not privy to the discussions that they had with the testator and his wife. Mrs. Archana Mukherjee, who resided in Kolkata, came over daily to our residence to see her parents. She would come in every day in the morning after me and my husband left for work and return late in the evening.
How were the proceeds of the Sheikhpura land finally distributed?
The Sheikhpura land was held in 3 parts. One part was owned by Mrs. Archana Mukherjee. The second part was owned by Mrs. Chandana Chatterjee. And the rest was owned by the testator. Post the sale of this land, Mrs. Archana Mukherjee and Mrs. Chandana Chatterjee received the considerations for the parts that they held, while from the proceeds received by the testator, from the proceeds received by the testator, 3 flats were purchased jointly with 3 of his daughters, namely Mrs. Ranjana Chakraborty, Mrs. Malavika Ganguly, and Mrs. Oli Gangopadhyay. Subsequently, the daughters got the testator to remove his name from the allotment letters, although no registered deed of gift was executed with respect to these 3 flats. The daughters manufactured this ingenious process to appropriate the flats and dissipate the estate of the testator.
When, according to you, did the deletion of the name of the testator as deposed by you in answer to the previous question take place? As deposed by you in answer to the previous question take place?
I am not aware of the exact date. However, all of this happened after the testator and his wife were removed from our Roland Road residence.
You have just deposed that out of the 3 flats purchased from the consideration of the Sheikhpura land, you have just deposed that from the consideration received by the testator for the Sheikhpura land, 3 flats were purchased by him jointly with Ranjana Chakraborty, Malavika Ganguly, and Oli Gangopadhyay. Are any of the plaintiffs related to these 3 daughters of the testator? Are any of the plaintiffs in this suit?
Yes, they are.
Can you please name him?
Dr. Bhaskar Ganguly was one of them.
After the removal of the testator from the Roland Road flat, did your husband or you meet
You
the
see,
test?
put a question which is not a leading question.
I have not led her.
No, you are putting either or. You just.
I did not say. She has said that the parents-in-law were removed. I am saying after the removal.
Yes.
Did you or your husband meet the testator and his wife?
Yes, that means she has to say yes or no.
Very well. I'll rephrase the question.
Put it in a different way.
I'll come back to that. Who was responsible for the medical affairs of the testator after their removal to the Rupchand Mukherjee Road flat?
Mrs. Archana Mukherjee and her husband, Mr. Bijon Mukherjee, were the ones responsible for handling the testator's medical affairs post the removal from the Roland Road residence.
What was the role of your husband in the medical affairs of the testator after the removal of the testator and his wife from the Roland Road residence?
After the testator and his wife were removed from our Roland Road residence, both my husband, Dr. Probir Kumar Banerjee, and myself, we did not have any access whatsoever with the testator and his wife, although we made quite a few attempts. And this access was denied by Mrs. Archana Mukherjee and Mr. Bijon Mukherjee, who had by that time had taken complete charge of the testator and his affairs.
The plaintiff's second witness, Dr. Bhaskar Ganguly, has deposed of the testator having been hospitalized on various occasions after being shifted to Rupchand Mukherjee Road. What do you have to say about the said hospitalizations?
The hospitalizations that took place after the testator and his wife were removed from our Roland Road residence, we were actually, both my husband and myself, were not even informed about their hospitalization. It is just because Dr. Probir Kumar Banerjee was associated with PLS Hospital that he came to know of his father's admission. Although access was denied and he could not even visit his father.
On question number 30. And the answer thereto given by the plaintiff's witness number 2, Dr. Bhaskar Ganguly. Dr. Bhaskar Ganguly টা দেখাবে। Question number 30 and answer. এটা কারটা দেখালে? না, ওনারটা তো দেখাইনি।
That is what PW1?
PW2.
PW2.
আরেকদিন করে সাজেশন করে নিতে এক গাদা যে দিয়েছো বল আরেকদিন দেখো শুনে রাখো ভাই আরে এখানে হবে না তো কমিশনে সাক্ষী হয়েছিল হ্যাঁ কমিশনে কেন হবে কেন ভাস্কর গাঙ্গুলি তো কমিশনে সাক্ষী হয়েছিল জয়ন্ত কমিশনার ছিল না
ও জয়ন্তর এটা কমিশনের রিপোর্ট আছে, জয়ন্ত কমিশনের ছিল। হ্যাঁ দেখো এটা কি জয়ন্ত?
হ্যাঁ এটাই হবে।
এটা জয়ন্ত না, এটা তো তোমরা দেখো না কাজ শুরু আছে।
স্পেশাল অফিসার না, এটা না।
এটা জয়ন্ত আরেকটা আছে।
Question number?
দেখি। ও এটা ছিল না জয়ন্ত।
Question number 30 of branch.
এটা গৌরীশঙ্কর গুপ্ত, এটা গৌরীশঙ্কর গুপ্ত।
আমাদেরটা দেখিয়ে দিই না, দেখিয়ে দাও না।
ওখানে দেখুন দুটো হবে, একটা
ওটা নয়, এটা নিয়ে যাও।
এইটা হবে। তোর কাছে হয়েছিল পিএস গুপ্ত। May I show the witness my copy?
Yes.
May I show the witness my copy?
এগুলো সব এবার বসে মানে we'll organize the papers, man. I'll tell my
So 2 witnesses have already deposed.
Yes.
witness from my side. হ্যাঁ এটা খোলা হয়নি তাহলে। 2-3টে কমিশন হয়েছে তো সব এইটাই this
If you have a copy, you can do that.
but this has to be open because any event because the
Opened
court
anyways.
recorded, any event opened anyways, but you can start, you can continue with your copy. দেখিয়ে দাও
আমার কপিটা দাও, আমারটা একটু মার্ক লাগে দেখি।
মার্ক তো কি হয়েছে, আনসারটা তো লেখা নেই তাহলে। আরে 40 না মার্কিং, আনসারটা থোড়ি লেখা আছে তোমার।
তো এখানে
আরে মা, আনসারটা তো লেখা নেই।
কি বললাম দিদি? কোন given by
the plaintiff.
plaintiff's second witness, Dr. Bhaskar Ganguly. ওটাই দিয়ে দিবি। দিন ওটা আমাকে, আমাকে দিন। What do you have to say about the allegation made, open inverted comma, thereafter when he was admitted for the first time in February in Peerless Hospital, comma, he did not receive the expected care as it was given in the past, full stop. However, comma, the caregivers were disappointed, but nonetheless, when he again fell ill at the end of March, comma, 2009, he was again taken to Peerless Hospital with the hope that the best quality of care would be given, full stop. Unfortunately, comma, this did not transpire, full stop, close inverted commas.
This is completely incorrect. Dr. Banerjee was not even given access to see his father. So therefore, the question of not given access to visit his father. So the question of not taking care of him does not arise.
By Dr. Banerjee, in answer to the previous question, who are you referring to?
I meant Dr. Probir Kumar Banerjee, my husband.
When did the testator pass away?
The testator passed away on 21st May 2009.
Now, between the removal of your father-in-law, of the testator and his wife from the Roland Road residence and his death on 21st May 2009, who admitted the testator in the event of hospitalization?
To my knowledge, the admissions were done by his daughters.
I once again draw your attention to the answer given by the plaintiff's witness number 2 to question 30, where the said witness has referred to three hospitalizations, two in Peerless Hospital and one in AMRI. Are you in a position to tell this honorable court under whose supervision the testator was admitted to Peerless Hospital and AMRI respectively?
The admissions referred to here have been done under various doctors. Till such time, the testator was with us at a Roland Road residence. The admission has always been under his son, Dr. Probir Kumar Banerjee's care. But post their removal, there were various doctors under whose care the testator was admitted.
When were you first informed of the death of the testator?
We were informed about the testator's demise on the 21st of May 2009, later in the day, by one of Dr. Probir Kumar Banerjee's cousin.
Where did your father-in-law pass away?
As per the cousin who informed us of the testator's demise and other relatives, the testator passed away at his Roopchand Mukherjee Lane residence. However, during the proceedings of this case, we got to learn that the testator passed away at AMRI Dhakuria Hospital, Kolkata. There seems to be a disconnect there.
Who performed the last rites of the deceased?
Who performed the last rites
Of the testator, deceased, of the testator.
When my husband and myself, we reached the crematorium, a huge chaos followed.
No, the question is who performed the last rites?
I'm coming
Yes.
to that. As the daughters of the testator and their husbands were reluctant to allow my husband, Dr. Probir Kumar Banerjee, to perform the Mukhagni and the last rites. However, on the insistence of the senior relatives who were present there, finally, Dr. Probir Kumar Banerjee could perform the Mukhagni and the last rites as per the norms.
Who performed the Shraddha ceremony of the testator?
The Shraddha ceremony of the testator was performed by my husband, Dr. Probir Kumar Banerjee. The Shraddha ceremony was performed by my husband, Dr. Probir Kumar Banerjee, although to spite him, the daughters of the testator performed another Shraddha ceremony on the same date at a different venue. At a different venue.
May I stop here today? I will take one more day and then they can process.
Yes.
Correction I have made the corrections, my lord. I've circulated them to my learned friend. He does not have any objection, my lord. These may be incorporated, my lord.
Yes, record an order. Learned advocates for the parties are present. DW1. Yes, what is her name?
Shomi Banerjee.
DW1, MS Shomi Banerjee is present in court. DW1 is further examined in chief and discharged for the day. So, let learned advocates for the parties submits that there were some errors in the recording of the deposition of DW1. Let this error be corrected. Let this matter appear for further examination of DW1 on 19 আগস্ট দেখুন তো 18-19 তারিখে
Any day other than the 18th, my lord.
19 তারিখে দেখুন দুটোর সময় 20 তারিখে আর কি পেলে
3 p.m. on 20th.
20th
3 p.m.
20th at 2 p.m.
2 p.m.
Yes, yes, because there is another matter. It may take some time. So I'm for abundant caution, I'm keeping it at 2 p.m.
Yes. Appearance দিয়ে দিচ্ছি। Obliged.
Yes, call the other matters. চারটের সময় নাকি কল করে দিন
Should matter item number 30. Your Lordship, I am appearing on behalf of the defendant bank. Your Lordship,
plaintiff is not present.
No, the plaintiff is not present. Your Lordship was pleased to direct the Administrator General to serve copy to both the parties. Although we have filed affidavit of service to the other side. Kindly, your lordship, kindly, if your lordship, kindly
Let me
check the
see the
record,
order.
your lordship.
Passed on the last day.
They are not ready and willing to proceed with the suit, your lordship. Kindly pass necessary order. One report should have been filed by
এটা
the-
administrative notice issue হয়েছে?
Yes, yes, your lordship. We have also received the administrative notice, your lordship.
5th August.
The suit may be dismissed, your lordship.
এই অন্য রিপোর্টটা দিন। হ্যাঁ? Yes, record an order. Learned advocate for the defendant is present, none appears for the plaintiff. It appears that by order dated, that pursuant to order dated June 30, 2025, administrative notice was issued upon the learned advocate for the plaintiff. Stop. Although notice was sent to the plaintiff, but the sealed envelope returned with the remark that the plaintiff is not lying in the said address. Stop. As none appeared for the plaintiff in spite of service of notice upon the learned advocate for the plaintiff, this suit stands dismissed for default.
Item number 31.
Lordship, item number 31, I'm for the petitioner, I'm for the plaintiff. Lordship, on the last occasion, it was submitted that the plaintiff number 4, she's undergoing liver transplant, but in the meantime, Lordship, she is facing more difficulties, Lordship.
Anyway, keeping it in the month of September.
Lordship, kindly, it may be after vacation because she is undergoing also liver, along with liver transplant,
Yes,
she is
record
also
an-
getting renal transplant, which is kidney.
Learned
She's suffering from
advocate for
CKD.
the plaintiff appears and prays for time due to ailments of the plaintiff. Plaintiff number 1.
4.
Plaintiff number 4. In the facts and circumstances, the matter stands adjourned till 3/11/2025.
Grateful, my lord.
Item number 32,
Not today.
33,
Not today.
34,
Not today.
35,
My lord, my senior advocate Shorash
Item 35.
Item 35. Item 35.
In the goods of Pashupatinath Banerjee.
Yes. My senior is not available to.
Anyway, not this week.
Not today. Thank you.
ঠিক আছে এবার হ্যাঁ আসি ঘুরে আসি 4টের সময়
আচ্ছা তোমার কাছে ঠিক আছে
এই
PM fixed matter.
My lord, I am.
Yes, today is fixed for framing of issues.
My lord, framing of issues as well as the affidavit of document. I have served a copy of the affidavit document. And also on the last occasion, my lord, I have submitted that affidavit of documents on behalf of my client, defendant number 3, as well as the suggested. My lord, that issue I have raised, my lord, kindly consider.
Where is that issue? Let me see.
Filed. Last occasion issue টা filed হয়েছে।
Last occasion I have filed.
Issues থাকি দেবে।
Lord, the issues suggested, my lord, my clients behalf, my lord. That is in pursuance to the amended clause. I have not gone beyond the scope of that amended issue.
Earlier, how many issues were framed?
Seven, Lord.
7.
My lord.
Lord, these issues are.
So you can also
Lord,
file
order-
for suggested issues.
Lord, order dated 10th December 2024. Your lordship will find that 7 issues were framed.
Thereafter,
Pursuant to-
this amendment was carried out.
Yes, Lord.
So some additional issues
My lord.
come.
Yes, Lord.
So your learned friend has filed the suggested issues. You can file your suggested issues also. Thereafter, the issues will be framed.
My lord, my lord, unless,
আপনার suggested issues to-
my lord, I am handing over the copy of the judgment.
না জজ সাহেবের যেটা বক্তব্য উনি যতক্ষণ সাজেস্টেড ইস্যু না ফাইল করছেন
This judgment regarding
Order 14, my lord. My lord, this is, my lord, if your lordship kindly come, paragraph 20. Paragraph 20. This is reported in 2001-2 Supreme Court cases 652. Paragraph 19. My lord, it's a arising out of, my lord, that election petition. My lord,
Yes.
it is an election petition is like a civil strife. My lord, paragraph 19. My lord, the stage of framing the issues is an important one inasmuch as on that day the scope of the trial is determined by laying the path on the which the trial shall proceed, exceeding the diversions and departures therefrom. The date fixed for settlement of issues is therefore a date fixed for hearing. The real dispute between the parties is determined. The area of conflict is narrowed and the concave mirror held by the court reflecting the pleadings of the parties in points into issues. The disputes on which the two sides differ. My lord, this is very important. The correct decisions of civil list largely depends on correct framing of issues. Correctly determining the real points in controversy which need to be decided. My lord, here the amendment on certain facts.
No one is disputing this,
Yes.
Lord.
So-
I'm not disputing this proposition. Why my learned friend is taking this time, I don't know.
Because I am submitting. Because
Yes,
all the-
additional issues are required to be framed. I agree.
Yes, you see, the issues shall be framed and recorded, which decision of the case shall be final. The parties and their counsel are bound to assist the court in the framing of
Yes,
the
my lord.
issues.
My lord.
Duty of the counsel does not belittle the primary obligation cast on the court.
My lord, on that score, my lord, 1978, AIN 97, Allahabad 360 is on the same footings, man. Same. I'm not troubling your lordship to show further because this judgment.
Anyway,
is
you have given your suggested issues. You have exchanged the same with your learned friend also.
My lord.
So let your learned friend file his suggested issues. Thereafter, the
Lord,
court will-
another submission, Lord, my learned friend has filed the affidavit of documents, Lord.
Yes.
additional affidavit of documents.
Not
No.
additional. This is the
They
first
did not,
time.
this is the first time they are disclosing.
Yes.
In the It is earlier, a comprehensive way, entire thing,
Entire thing.
taking into consideration the
Yes,
amendment.
my
Lord, earlier,
My lord, no judge's brief of documents has been furnished.
24/7.
Certain documents has been given to me. There is some, my lord, arguable point.
Lord,
is that-
judge's brief has been prepared.
No.
My learned friend was asked to take the inspection. He has taken the inspection. I have the
I am not-
documents,
I am
Lord.
not. My lord,
I'm just
my lord,
giving. In that case,
because
I am
am
giving.
not being served with the judge's brief of document. My lord, now facts comes to your lordship that if my affidavit of documents is accepted, so these will be again included in the judge's brief document at the instance of the plaintiff. Let them do it. I have no objection.
No, you are filing your judge's brief of
I got,
documents.
yes.
No, as per,
For the
no, I have recorded in my order, probably it is affidavit, yes, affidavit of documents, my defendant number 3.
Yes, yes.
Copy be served.
Because your lordship was pleased to hear that since your application for amendment was allowed.
You have filed your additional suggested issue.
My lord, I have filed. I have filed.
Regarding, so this is your first judge's brief of documents. This is
My
not
lord,
additional.
Affidavit of documents.
Affidavit of
Judge's brief
documents.
Documents will be prepared by the plaintiff under the original side rules. My lord.
Lord, earlier we
Let
have,
them- Let them file the additional.
all the other defendants had filed their affidavit of documents, Lord, pursuant to which judge's
My
brief
lord,
was
I am not
prepared.
concerned with the other defendants, my lord. Nobody is there. I am.
So
here.
judge's brief of
That's-
documents is yet to be filed. No, it has been prepared and filed. Thereafter, my learned friend has carried out this amendment.
Hereafter,
And
he
now,
has filed his affidavit of
in
documents.
the earlier occasion, Lord, when the chances were given to file the affidavit of documents, Lord, they did not choose. They said that their client is ill, so we are asked for extension of time. Ultimately,
No,
the
from your side, affidavit of documents and judge's brief of documents, entire thing is complete.
entire thing is complete.
Now
Now
the-
they are
Oh,
filing
for this amendment, your learned friend had to file this
additional judge's brief, Lord.
no, affidavit of documents. Affidavit of documents. As well
So
as he has filed the
But
additional.
inspection has not been given. I have asked by a letter for inspection, not inspection is
No,
required
I
to
have
be.
made it clear. So copy.
Documents are here, my lord.
Yes, copy,
Original-
yes, copy has been served, but inspection not given.
Not the inspection given.
Let them take the inspection. I have no objection, man.
Because in their document, Lord, in their affidavit, they have given the list only.
Certainly.
So the documents are required to be inspected.
Let them require.
And whatever is admissible, we will admit. Whichever is disputed, we will dispute that. And on the basis of that, judge's brief, additional judge's brief will required to be filed. Lord.
Inspection. In the meantime, my lord, let them file the.
So I am
granting you opportunity to cause inspection of the affidavit of document filed by your learned friend,
My lord.
and thereafter prepare the judge's brief of additional judge's brief of documents. No additional, my lord. Enter judge's brief of documents. No, here your learned friend has filed. They have not served any copy of the original judge's brief of document. We have not been served. If they have not served, they will serve you. Judge's brief of documents, they have given me. All along you are there as advocate on record. All along there. I am for the defendant. You just cause inspections, you verify from your office whether it has been done or not. Your learned friend will also verify. He will cooperate, I will also cooperate. No problem. Yes, Mr. Mukherjee, if it is not, inspection is not given to him, you give inspection with regard to your documents.
Yes, no.
Now the question left is, he has to give you inspection with regard to the additional, not additional, entire affidavit of documents. Copy has been served, but the inspection has not been given. No inspection given in an earlier occasion. No judge's brief document filed, your lordship. Unless it is filed, my lord, the suit is not ready under the original side rules, my lord. So, but the documents. So after filing the judge's brief of documents, if not filed, you have to come with your suggested issues also. If you so desire.
Yes. Suggested issues, we have filed additional suggested issues.
Additional suggested issues. Yes, record and order. My lord, a little time be given, my lord, a little bigger time, because unless Because my client, he will come with all the original documents, my lord.
Learned advocate for the plaintiff and learned advocate for the defendant number 3 are present. Today is fixed for framing of issues. Learned advocate for the defendant 3 has filed the suggested issues, additional suggested issues. Let the same be kept with the record. Copy be served upon the plaintiff if not already served. Plaintiff is also granted opportunity to file the additional suggested issues. It is submitted by the learned advocates that the affidavit of documents which has been filed and copies served are yet to be inspected by the plaintiff. Thus, the inspection of
Plaintiff and the defendant.
plaintiff and the other defendants.
The
Okay, plaintiff and the defendant. Let the inspection of the documents be carried out on or before 21
My lord, after 25th, because I have some.
on or before 26
My lord.
on or before 26/8/2025. Let this matter appear on 27/8/2025 at 4 p.m. Upon necessary inspection of the documents, let the judge's brief of documents be prepared and filed on the next date fixed.
On the next date, but not by the 27th.
No, on the next date fixed, I am keeping it on 27th.
My lord, that the judge's brief document.
Judge's brief should be filed after that, my lord.
After that, because it not to be possible.
No, 27 is for framing of issues.
On framing of issue. After inspection.
After inspection.
After completion of inspection.
So definitely
Discovery has to be completed.
Before 27th, the entire thing will be completed.
My lord, the judge's brief cannot.
It will
Okay, 27 judges brief ta kete din. 27th for framing of the issues.
And completion of the discovery process.
And completion of the discovery and inspection. So simplicity of framing of issues on 27th. 27th at 4 p.m.
At 4.
And in the meantime, my lord, the inspection will be held.
Yes.
I am declared.
Lord, I am also filing one. I have served upon my learned friend, Lord, one additional document, Lord. After the
additional affidavit of documents filed be kept with the record and copy be served upon all the defendants.
already served.
Already served.
All the
I have
defendants.
I have served.
If not already served.
If not already.
Be kept with the record, copy be served upon all the defendants, if not already served.
একজন আছে দিয়ে দাও।
May I take back that the judgment part, my lord?
Yes, yes.
Because
Take
on
it
the
back.
next date, it will be required, my lord. I am declared. আপনি তো দেওয়া হয়নি বিরাট তুমি দেখো দেখে নিচ্ছি